Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
We're getting commentary on the case. Dati mihi Anglican for his service Latino. I didn't ask you to interrupt me. Oh, for crumb's sake.
All right. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining me this morning. Happy Tuesday morning to you. Should be Tuesday. Yes, I had to check. It is Tuesday. Wonderful to be here with all of you, especially to my great friend Bug Dugger. First in chat this morning. I believe I haven't pulled your record, your rap sheet, but I believe this may be a first offense for you. This is the first time you've been first in chat. You don't know that being first in chat comes with a penalty, a prize, depending on how you view it, of internet ownership. But ignorance is not an excuse for the law, and you were first in chat, and thus I am going to find you guilty of being so, and assign you a penalty of owning the internet and maintaining ownership and just basically maintaining the internet throughout the day until we go live again. So congratulations, Bug Dugger, or good riddance, or my condolences, however you want to view that. Thank you very much. All right, it is a good day. It's a good day. I have to say, I do apologize. A few of you, a couple hundred of you, I owe an apology to. I made you sit and wait through an hour or some odd of Judge Boyd's break, which I thought was going to be 5 minutes, and it ended up being an hour. And then at the very end, I closed out the show. I said my piece at the end. I played the music. I faded to my little Recovery Addict screen, and then I waited for a whole of like 5 seconds, and immediately Judge Boyd came back. And so I went live again just for a minute, but then I thought about all those people who thought that, oh no, the show's over, I'll watch it tomorrow. And I said, we can't really watch it now because you guys, so yes, we're going to pick up right when she came back yesterday. So a few of you did I sent you over to Judge Boyd's channel to watch directly. A few of you know what's going to happen. Let's not spoil it for those of us who waited, and I'm one of those who waited. I don't know what's coming. I know it's going to be spicy because I've heard rumblings that there's some spiciness there. And the good news, Greeners, yes, the good news is we can actually we can watch at 1.5 speed if we need to, if the defense decides to go slowly again, as they have thus far. Which is good. I am working on behind the scenes. That case, I forget, who was it that first tipped me off about the case up in Washington with the 3 police officers, the murder trial with 3 police officers as defendants. We're working behind the scenes to see if we can get access to that. They're still in jury selection today. It started yesterday. The trial itself is not slated to start early October, so we're requesting paperwork to the court, seeing how that works. I know King 5 is airing it live. They're going to be the pool camera of record, I believe, and we're trying to see how we can get that sorted out. So let me continue to work on that. I'll file some paperwork today and see if we can be found in the judge's good graces, and we'll move forward with that. That is an 8 to 12 week trial. Oh my goodness, that is a long time. That takes us all the way back to Murdaugh. That was a long trial as well. It's a very, very long trial. You've got 3 defendants as up for murder, and police officers at that. There's video. There's a lot that comes into this. Anyway, so that's coming up. Let's before we get started, because we have to kick this off. I think the judge is starting early this morning in Texas, well, early for her. So we have to get caught up. Otherwise, we'll be catching up to the live this morning, and then we'll go from 1.5 speed to suddenly real time when we hit live. But either way, I think we're going to get caught up today. And we'll be able to follow the closings that should be happening starting today. Do we have any birthdays before we begin? I'll give you just a minute, or maybe if the mods have made a nice collection for me, if they can just tell me whose birthdays have popped up in chat, because I was not reading. I was not paying attention. I promise. I will do better. Let's see. Let me. I know what we need before we sing. Assuming somebody has a birthday, there must be a little bit of beverage consumption. Okay, Kieran Baines, is it Kieran? Kieran, can you give me a thumbs up if I said Kieran correctly? Or is it Kieran? Thumbs down if it's Kieran, thumbs up if it's Kieran. I'm getting pictures sent to the burner phone, which I need to turn on here. Just 1 second. I don't know who sent me the drawing of what they envisioned was happening on the screen yesterday, but it was the video. It was hilarious. This little stick figure drawing. It's so good. Let's see. Oh, John Davenport sent pictures of cheer wine. He found it in bottles, like glass bottles. I've never seen it. I've always seen it in cans and plastic. All right, so. Kieran Baines. Anyone else's birthday? I can't see the thumbs up or not. Okay. Here it is. Kieran is my guess, says Greeners. Anybody else who shares a birthday with Kieran? Carrion? Thumbs up was thumbs up on Kieran. Okay, I'm going to do Kieran then. I'm going to do Kieran. And if I got it wrong and I messed it up, I do apologize. Know that my intent was to get it right. Okay, anybody else? Skookle. Okay, yes, I mess up everything. Kyron. Okay, Kyron. Final answer, Kyron. Anybody share a birthday with Kyron? Let's see. Angelica, we'll sing to you as well, even though your birthday was on the 8th. There's a buffer sound, which means I missed something. Nina Canadian, their birthday was on Sunday. Okay, so Nina. Hang on, Nina. I need time to break out the notes, or else we're never going to remember. Nina, Kyron, and I just said the last one, Angelica. Okay. All right. I think that is all of the people who have a birthday today, so we can sing to them. Red pen. Oh man, it's not that bad, is it? Okay, here we go. La 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 la. Happy birthday to you. Happy birthday to you. Happy birthday, Nina, Kieran, and Angelica. Happy birthday to you. Kyron, I butchered it in the middle, and I do apologize. I tried. Please just replace whatever I said with your name and know that that's what I meant to say. I'm sorry. For all those who are having birthdays today, even if you're here or maybe join us later on, I hope you have a fantastic day. I realize there are a million places you could spend your birthday, and the idea that you want to be, and Jamie's boss's birthday. Happy birthday, Jamie's boss as well. There are a million places you could be to celebrate your birthday, and a lot of them are really cool and really fun, and it's not lost on me that you chose to be here with us, and we are honored to share this special day with you. So thank you very much. Have a fantastic birthday, and have wonderful presents and all the attention you deserve. So thank you very much. All right, we are going to Kieran. It would help if I knew how to pronounce words to begin with. So when people give me the pronunciation guides, if I knew how to read them, it would be better. But I don't. Red pen. I'm going to need your assistance. Spell this out in crayon as you would to a child, to help me understand how to pronounce these names. Kieran, thank you very much. We'll say Kieran, and I'll forget. Kieran. Kieran. Oh yeah. Okay, I messed it up. All right, I do apologize. It is your birthday though. However, I don't know where I was going to say what I was going to say with that word, but it is your birthday. I hope you have a great one. Thank you so much for sharing it with us. Okay, where we're at now. Let's see. The meeting last night went well. By the way, we had the meeting. We had to sort of drop everything and. I apologize. It is terrible. My pronunciation is terrible. I will mess up many things in the future. I promise. The meeting went really well, and we had like a lessons learned thing. And I think the next time we do this, we're not going to hire out. We're just going to have me do it all. I think I'll need to buy a little bit of equipment. I always need to buy one more thing, right? I need to buy a pan tilt zoom camera, which is fun. Anyway, that was fun. It was a great meeting, and now we're back to court. We are going to pick up right where we left off. I have a friend named Kyron, and it was pronounced Kieran. I have a friend named Kirsten, similar starting to the spelling, and I always struggle with that. It's the I and the E that you mix them up, and I have no idea what to do with the sounds. All rise. Court is now in session. It is now in session. We're going to go ahead and start. We're picking up right where we left off when the break ended. As the break ended, we picked up with the judge. Let's see. Right here. I think this is it.
The person from the
state. You want to come up?
Yeah, the break ended, and immediately there was a sidebar.
Has a form.
Yeah.
That he says that he was never adjudicated or something like that.
Mm-hmm.
Will the court allow me to get into that?
I mean, you can question the gun shop owner about what is on the form because he's coming in as a custodian of records. You can question him about that.
Okay.
Okay. And I'm sorry, State, you can come forward.
Yes, Judge.
And then we don't get to hear the rest. But it sounds like they're going to talk about the mental adjudication of the victim, that he was never officially adjudicated as needing mental help or having a mental condition. Mm-hmm. And they're going to talk about the gun ownership.
No, I'm not going to check. Okay.
So let's see if they get started here.
Defense, you want to put your witness up here?
Yes.
And they also end up showing one of the jurors. Great. That's just awesome.
All right, let's.
It's that camera that sits. That's
all right, sir. If you'll take a seat here.
It's too far to the left.
And thank you for coming down.
My pleasure, ma'am.
All right.
Your Honor, I apologize.
Oh, no problem. All right, let's bring the jurors in.
It sounds like this guy wasn't subpoenaed or was on very short notice. Yep. We're about to see one of the jurors. It's going to happen. Christy, welcome to the gallery. 7 months. 7 months. Look at that. Thank you so much, Christy. Great supporter. Been here a long time. So we have where we are in the trial. The state just rested. We took a long break.
All right, everyone, please be seated. All right, defense, call your witness.
Okay.
All right, sir, would you state your name, please?
Jonathan Rayner.
All right, Mr. Rayner, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
So help me God.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear and so that the court reporter can hear. Defense?
Okay. Sir, how are you employed?
How am I employed?
Yes. Who you employed by?
Norris Gun Club.
Gun club.
And could you spell that, please?
NARDIS.
Okay. Now, did you, you were asked to, I'm sorry. Okay. When you were asked to come down and testify in this case, were you were actually bringing any records?
Just my ATF form 4473.
Okay, and could you explain exactly what that form is and what it does?
So essentially, anytime you go into a gun store, you must fill out ATF form 4473, whether it be a pawn shop or even a actual gun store, which you're more than likely going to guarantee to fill out. It is a federal document mandated by the Department of Justice and the ATF, and I must fill out information regarding the firearm being sold.
Just 1 second. If you can slow down for the court reporter.
Okay.
The audio is awful too.
Information regarding the firearm, and also the customer must fill out his information, answering a questionnaire, their address, a couple of personal information, for example, like race, ethnicity, and birth date. And of course, once that's submitted, once they sign a date, I submit the background check to the FBI, also known as the NICS system.
And how do you spell the NICS system?
NICS.
Okay. And is all that's done before a person can actually purchase a weapon?
That is correct. So you must fill out the document. I must get a response back from the FBI regarding the background check, whether it's a proceed, a delay, or deny. As in this case, the individual was proceeded. The only time I take their payment when it's officially transferred is when I get the okay from the FBI, which again, a proceed.
Now, the person that was the subject matter of the document that you brought down today, do you recall that person's name?
Unfortunately, not by memory, but it really, if I had to be honest with you, if I had to see the gentleman today, I'm sure even I could remember him. And if I could give you a reason why, it's probably because he was a very level-headed individual. A lot of times, gentlemen's coming by a gun, there was anything that stood out in terms of any erratic behavior or essentially anything that gives any red flags. I deny so. In this case, as you can see, I went through the proceed because, well, nothing really stood out to me or anything that gave any sense of caution.
So he said he wouldn't recognize the
so
person.
So you were the person that actually did the sale in this case?
Did the sale and the background check.
Okay.
So he's explaining the process of buying a gun through a store.
It's fair to say say for instance, if just assume that something's overlooked by you all in the purchase or the sale of that weapon, who would your company have any legal issues or ramification if, say, something was not done according to the statute or the way it should be done?
Most definitely object to speculation.
All right, that'll be overruled.
Yeah, there is always a repercussion if there's any red flag, not say red flags, but anything that we don't follow protocol or even by the ATF and FBI can actually get our license revoked for one.
Okay.
So he says if he makes mistakes on this form, they can lose their license to sell firearms.
Yes.
He's explained the ATF form that gets submitted to the FBI for a background check for a firearm purchase through a store.
I think that you have before. This is what you brought over today, correct?
That's correct.
In this firearm transaction of the records, is this the original or is it a copy of the original?
This is a copy of the original. Must stay on premises with the business for 20 years until the ATF comes by and takes that document.
So the original copy has to say
that is correct, as required by the ATF, which is federal law.
Okay. And this is a exact copy of that original.
Exactly.
Defense is trying to say that the victim should not have had a gun. And they aren't getting very far because it appears that it was a legal purchase, which would indicate there was nothing in his background, or there shouldn't be anything in his background that would prevent him from buying one. Yeah, his audio is bad. We've heard it gets better after him, and I don't think he's going to be a very lengthy witness. He's labeling some evidence to admit it to the court. He's applied a sticker to it.
Want me to just put it on the back, Mr. Cox?
I'm thinking that's what PJ.
Judge tells him put the sticker on the back.
Sir, I'm going to show you what's been marked as. I think it's 2.
Defense 2.
Defendants exhibit number 2. Just a sticker on it, and this is the same copy that you brought to court with you today, correct? That's correct. And this exhibit number 2. I'm sorry, defense exhibit number 2 is a document that you keep in that your business keep these normal records that it maintains, correct? That's correct. Yeah, at this point, if there's no objection by the state, we ask that this document be moved into evidence as defendant exhibit number 2.
The document from Isaiah Roseville?
Correct.
Okay.
All right, defense exhibit number 2 is admitted without objection.
And it's fair to say, sir, that this document gives the purchase information, correct?
Right.
The serial numbers and those type of things for the weapon.
That is correct. Right.
And there's also a questionnaire, correct?
Yes, sir.
Okay. And when and there's several questions that a person needs to answer, and that's just typical protocol. They must do it before you're able to process them for purchasing a firearm, correct?
Right. So I cannot even process a background check until that questionnaire has been signed and dated.
And on the second page of that document, there's an alphabet F. If you look at that page on defense 2, and there's a question.
Yes, sir.
Would you mind reading that question to me?
Excuse me, just 1 second. I need you to slow down.
Sorry.
And if you could, for the court reporter, she doesn't like it when you do foxtrot and whiskey. If you'll just say the letters.
Have you ever been adjudicated as a mental defective, or have you ever been committed to a mental institution? In this case, the answer is no.
The question was, have you ever been ruled mentally adjudicated,
And
mentally
when
incompetent, or admitted to a mental institution? He said no.
When you do the background on those things, is the FBI that does a background for you or no?
That is correct. So that's what NICS is managed by. It's by the Federal Bureau of Investigation. So essentially, it is a software program managed by the Federal Bureau of Investigation. Essentially, on this document, I input that information into NICS. Put all that information in, I verify if everything is correct, I click submit, and then I wait for a response. That can be proceed, which means go ahead with the sale. A delay just means it's going to take a few extra days for the background check. And a deny simply says that they're not able to buy that firearm.
I'll pass with.
All right, state.
Nothing from the state.
All right, is this witness excused or subject for recall?
Excused from the state.
Subject to recall.
All right, could I have parties approach?
Subject to recall. It's his own witness. He's just called the dude. He says they don't have any more questions for him, but subject to recall. I believe we only got 2 witnesses that have actually been excused from testifying. And this guy...
Right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state or the defense, as long as the case is pending. Do you understand?
Yes, ma'am.
All right, thank you.
I apologize. It's just I deal with so many people in the kind of... I deal I'm a salesman, not so much I won't deal with the law. I apologize, Your Honor.
No problem. Thank you so much. And if you'll leave the exhibit with the court reporter.
My pleasure, ma'am.
All right. No problem. Thank you so much.
The guy came down on a really short notice. I think he was...
All right, defense, call your next witness.
Subpoenaed yesterday.
Jason Lexion.
Another witness.
All right, and with the last witness, if someone can make sure he knows, great, thank you. All right, if you'll take a seat here. Because we're after hours, there's a different way to leave the courthouse.
This was late last night. They're talking about after hours.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so the jurors can hear and the court reporter can hear. If you'll state your name and spell it for the record, please.
My name is Jason Lexion, Jaysonlexion.
All right, defense.
Okay. Yes, ma'am. Sir, I just want to draw your attention to an incident that happened last year, February 28th, I believe, 2022.
Yes, sir.
Okay. And do you remember being at a location where there was a shooting?
Yes, sir.
And do you recall being asked questions or being questioned by the police?
Yes, sir.
Okay. Now, do you remember roughly what time that incident happened? About what time?
I can't really call it. There was something going on. I can't really recall it exactly what time. But it was during the morning.
It was in the morning time?
Yes, sir.
Okay. And do you recall whether you were near a bus stop?
Yes, sir.
Okay. Do you remember where that bus stop was located?
Right around the corner from Sushi Sushi restaurant.
Okay. And that was
Is this the fist bump friend?
South St. Mary's, on St. Mary's?
I believe that was St. Mary's. I believe St. Mary's, yes, sir.
Now, do you recall, if you do, where you en route to go somewhere? Were you waiting on the bus, or what were you kind of doing?
En route, waiting on the bus to go home that day, that morning.
Okay. So pretty much up to that time when this shooting occurred, could you say it was just a regular day?
Yes, sir.
Did you happen to meet someone that you knew that day?
Didn't meet up, but we ran into each other.
Okay, you ran into somebody.
Yes, sir.
So was it a planned situation to meet up with this person or no?
Not at all.
Okay. And do you recall the person's name, the person that you met up with, that you happened to run into?
Yes, sir.
Who was that?
Joseph.
Okay. And is that the same person as do you see him in the court?
Yes, sir.
Okay. Could you just point to him and show us an article and describe an article of clothing that he's wearing?
A suit.
Okay.
A suit.
Is he wearing a tie?
He didn't point.
What color is the tie?
He didn't point. He just said a suit.
Yes, sir.
Let the record reflect that the witnesses identified Mr. Harris. Now,
this is a murder trial.
In terms of when you met with him or you ran into him, was it at the bus stop?
Yes, sir.
Okay. And did y'all start having like conversations?
But yeah, we did.
Just
about life.
Okay. Now, what if anything unusual happened while you were at that bus stop?
Repeat that again.
What did anything unusual happen while you were at that bus stop?
Some guy came around there belligerent while we was at the bus stop.
Okay. Now you say some guy. Could you describe that person, the victim?
I'm going to stop talking over one another.
Sorry. Okay. Do you recall like how tall that person was, or was it skinny or fat? Large?
He was skinny.
Okay. Was he Black, Hispanic, or was he a Black person, or was he Hispanic?
I thought he was Hispanic and Chinese, if I could say that. But.
Okay. Now, what was unusual about, what if anything was unusual about that person?
He just looked real belligerent, like he was losing his mind. He just looking real belligerent, mental.
When you say he looked, or you talking about whether the way he looked or the way he acted when you say belligerent, could you explain that to the jury in terms of why you had that impression?
it's the way he was, he was interacting. He was like aggressive towards everybody. That was there. He was just yelling, belligerent. Just seemed like not in the right state of mind at the time.
Okay. Now, did he? Were there other people?
It was tourists. There was a lot of people at the bus stop in ready to catch the bus.
And do you recall anything that person was actually saying?
Objection, you say, Your Honor.
Sustained.
Was the person saying
screaming out, telling me, "Get away from here!" Blah blah blah.
Sustained. You need to just listen to the question and only answer the question that's asked of you. All right.
Now, you said that the person appeared to be screaming.
Yes, sir.
And did anything that the person said cause you to say be alarmed?
Objection, you say, Your Honor.
Overruled.
You can answer. Did it cause you to be alarmed?
Yeah, I was concerned. I mean, everybody just took out running, once they seen that, it was kind of alarming.
Okay. Now, at this point, what, if anything, did you see that person? I'll strike that and go forward. Was he yelling in your direction or you in Joseph's direction? Was he
just that direction, period, at the time?
Okay. And at that point, had you or Joseph said anything to him or did anything to him at this point?
I mean, no, sir. It was like a lot of commotion. So, everybody was screaming and talking. So, there was a lot of commotion going on whenever that occurred.
Okay. And at this point, you're seated or are you standing? Or
seated.
Okay. And at this point, you're still waiting on the bus.
Yes, sir.
At this point, do you see this person do anything?
He proceeded to pull up his shirt and had a gun, act like he was going to use it at that time. That's when everybody left, once they seen him with the gun. So.
And then what was the next thing that happened?
I heard gunshots after that.
Okay. And did you remain seated or did you get up from where you were seated?
I remained seated because the police came over there to ask me questions, so I stayed there for the police. I remained seated.
Were you scared?
I was. I thought I was gonna get shot myself. I thought I was gonna. I didn't know what his intention was, but not just me, but everybody that was there. I was scared.
State.
Yes, Your Honor. Thanks. Mr. Lex, I'm Jason Garahan, a prosecutor for the state.
Yes, sir.
Have you ever talked to me or any other prosecutor associated with this case?
No, not that I recall, sir.
You never have?
Just a police officer.
Just a police officer back when it happened on February 28, 2022. Is that correct?
Yes, sir.
Did you talk to defense counsel today?
Who did the defense counsel?
Mr.
Yes,
Grimes,
sir. Yes, sir.
Question.
Excuse me, I need one at a time, please.
Yes, sir.
Now, you're an acquaintance, or at least you consider Mr. Joseph Harris, the defendant in this case, a friend of yours, right?
Yes, sir.
And so when you state that it wasn't planned, y'all met up downtown quite often, didn't y'all?
Yeah.
And so y'all used
after work or passing through, yes, sir.
Y'all even sometimes y'all had breakfast together.
I don't know about all that.
Well, if the defendant stated that y'all had breakfast together, would he be lying?
I don't remember, I really don't. I mean, I ain't saying that he lying, but it's been a long time. Probably I forgot that we had before, but.
Have you talked to him since this day, that February 28, 2022?
No, I don't know. Not that I haven't.
So you're not very good friends with him any longer?
I mean, it's still gonna remain the same. It just, I ain't known him that long, but he's Ain't no problem. He cool with me. There's no problem with him.
Well, talk about this day.
Yes, sir.
You stated that you saw the person that was shot, which has been identified in this case as Isaiah Orozco, by Joseph Harris. Are you aware of that?
Yes, sir.
And you saw Joseph Harris grab a gun. Where did Joseph Harris get his gun from?
No clue. I didn't see him grab no gun.
What's that?
I didn't see him grab a gun, so I don't know where he got it from.
Well, you saw him holding his gun, didn't you?
I mean, after I heard the gunshots, yeah.
After the gunshots?
Yeah.
So you don't recall Joseph Harris standing right next to you around this far when you're seated, pull this out from his waistband?
No, I didn't see that. I just heard the gunshots.
And you didn't see him run after Isaiah Orozco shooting 16 times?
No, I heard gunshots after. I didn't see him pull out nothing till after.
He shot 16 times.
That's when I knew that's when I heard him pull the gun out. After I heard the gun go off, then I knew he pulled the gun out. But at the beginning, no, I didn't see him pull out no gun.
Okay, just to clarify here. Is it your testimony that you did not see Joseph Harris grab this weapon?
I didn't see him pull it out at the time.
Just 1 second. All right, so you have to wait till the question is finished because it's difficult for the court reporter to take everything down. All right, you may ask your question.
No, I didn't see him pull it out. I just, after I heard the gunshot, then I knew he pulled it out then.
Did you see Joseph Harris chase Isaiah Orozco down the street?
I can't really say chase, but he walked up to him.
You didn't see this man over here chasing a person, shooting at him down the sidewalk when you were watching the whole time?
Not chasing, but walked up to him.
He walked up to him. Are you talking about the last shot when he walked up to him? He was sitting on the ground. He shot him in the head. Is that the one you're talking about?
If he shot him in the head, I mean, I didn't know that he shot him in the head.
You did, but you watched the whole time, didn't you?
Yes, sir.
But now your testimony today is that you don't remember.
No, I'm not saying I don't remember. I remember. I just don't remember seeing him pull out the gun.
Okay, so let's just clarify here for the jury.
Yes, sir.
Did you or did you not see Joseph Harris?
Judge asked and answered 5 times already.
All right, that'll be overruled. You can answer the question.
Chase down Isaiah Orozco, you sitting there at the bus stop watching it. Yes or no?
Watch him chase. I don't consider a chase. I started walking, but then we wasn't chasing. It wasn't like he was running. Like
You didn't see him running? Didn't see him jogging? Didn't see him pull out this weapon and chase an individual down the road?
I didn't see him chasing. I didn't see him walk.
How many shots did you hear?
About 12, maybe.
12. Do you recall the last shot?
Last shot I thought was in the back. I didn't know. Yeah.
In the back? How many times did he shoot Isaiah Orozco in the back?
Oh my goodness.
12, I guess. So he shot 8 to 12, I guess.
Shot 16 times. There were 16 shell casings that came in this trial. 16.
Yes, sir.
So can you tell the jury how many times you saw Joseph Harris shoot Isaiah Orozco in the back?
8 to 12. I didn't know how many clips hold, you know. I just.
And tell me this.
Yes, sir.
You saw Orozco. You said he had a gun in his waistband.
Yes, sir.
And you saw him take that gun out. And what did he do with that gun?
He proceeded to act like he was about to pull his gun out.
He was going to act like what?
He proceeded to act like he was going to pull the gun out and start shooting.
This is not a very good
I'll show you what's been marked.
defense.
Said exhibit number 67. Can you show me how he was acting like he was going to shoot?
He came up and he was like, "Hey, you need to move around."
I'm not asking what he said. I'm asking, you said just earlier in testimony that he was going to act like he was going to shoot. Please show. Judge, may he stand up?
Yes, you can step into the well.
If you're more comfortable there, you can stand up there.
So he proceeded to run up right around the corner. So yeah, there you go.
Yes.
So he had it like this, right?
Uh-huh.
And he said, "Hey, move around."
Not what he said. I'm asking how did he indicate that he was
That's
going
how
to
he did. He did pull the shifts. Hey, y'all move around.
Okay, not again. Again, not what he
Don't say
said.
what he said.
Okay, so what did you do with the gun after that? You know, you watched the whole time, didn't you?
Yeah, I seen it.
Here we go. Thank you.
Yes, sir.
Oh yeah, you can see. Sorry.
So he's saying the guy never drew
But
his
when
gun.
you saw this weapon, I'm assuming you kept your eyes on it, because you said you were alarmed by seeing this weapon.
Got kind of scared. Yes, I
Right.
did.
I mean, it's scary when somebody pulls a gun, right? Because what happens usually if somebody pulls a gun? People back off, right?
Yeah.
That's what Joseph Harris did, right? He backed off. Didn't he? He backed away from Isaiah Orozco. Do you recall that?
Can't get every detail, but I was scared. I wasn't trying to pay attention to everything, man. I was just like, dang, bro, I don't know what he gonna do with it. So.
But you kept your eyes on this the whole time, right? Where did it go after he displayed it? Did he point it at you?
No, he didn't point at me.
Did he point it at Joseph Harris?
No, he didn't.
Did he point it to anybody?
No, but no, he didn't.
What did he do with this gun after he showed it to you?
Threatened a lot of people with it. He threatened a lot of folks with it.
He threatened. Okay. Did he point it at you?
No, sir, not
Did
me.
he point it at Joseph Harris?
No, sir. We don't know who he's gonna point it at.
And listen to my question, please.
Yes, sir.
What did he do with this
He had in
firearm?
his band.
Got to wait till I finish my question.
Yes, sir.
What did he do with this firearm? Because you kept your eyes trained on it because you were alarmed and you were scared. What did he do with it?
It was still in his waistband.
Put it back in his waistband. And at that time, do you recall just Isaiah Orozco giving a hand signal like this? Remember him going like this?
I apologize. No, sir.
You got to remember this. When he turned his back to this man over here and started walking away, and then he was shot 16 times. You got to remember that. Yes or no?
Yes, sir.
And that's what happened, right? Have you seen the video of the Via bus?
No, I did.
Okay. Your Honor, State Exhibit number 71.
Now we're gonna show him exactly what he did, because he's on this video as well. So he's gonna see everything that happened right now. Defense witness literally just testified that the defendant shot the guy in the back 8 to 12 times. In the back. You can't do that. Let's watch this together. Seriously, yeah, we're going to be educated.
I stopped this video at 11:24:19 seconds. You see yourself in this photo.
Yes, sir.
And are you seated on a bench?
Yes, sir.
The back bench there, looking at, I'm assuming, the phone or something.
Yes, sir.
Do you have earbuds in? You recall telling an officer that you have earbuds in?
I did. I was listening to music.
Okay. So it's sort of hard to hear somebody threatening you if you have earbuds in, correct? Right?
Yes, sir. But I took it out to hear because I seen some.
Yeah.
Yeah.
But you told an officer at the scene that you had earbuds in. You couldn't really hear what was going on. Do you recall that?
Yes, sir.
Okay. So it's sort of hard to hear that threat when you have the earbuds in. Now, do you see Joseph Harris in this photo?
Yes, sir.
And is he this individual right here? Where I have the arrow.
Yes, sir.
And then you see this individual.
Yes, sir.
That is Isaiah Orozco. Do you recall? I know you probably don't know his name, but that's who that is.
Yes, sir.
That's the person that was shot, correct?
Yes, sir.
What is it seems like Isaiah Orozco is backing up. Is that right?
Yes, sir.
And it seems that your friend Joseph Harris is approaching him. Is that right? Yes or no, sir?
At that time?
Yes, sir.
Right here?
Yes.
They don't like you posing right then and there.
Well, was he approaching him just previous to this still photo?
They was talking. I don't know about approaching, but they was talking.
Okay, well, I guess the video will speak for itself.
Yes, sir. Now, yeah, he proceed.
It's the first time
Now,
I've seen this video.
It looks like it looks like Isaiah Roscoe is displaying something. What is he displaying?
That was a gun, I believe.
He's displaying this weapon, right?
Yes, sir.
And then what does Joseph Harris do after that is displayed to him? Backs away, doesn't he?
Yes, sir.
And do you see Isaiah Roscoe's hand gestures? Because look at your face. You have the earbuds in your ear.
Mm-hmm.
You're looking directly at him.
Mm-hmm.
So what was he doing?
I don't know what the hand gestures mean, but I guess maybe that's just a form of him talking with his hands. I don't know.
Mm-hmm. I'm sorry. And what is Isaiah Roscoe doing right there?
Taking off.
Taking off. Where are his hands? That right hand. You can see his hand, correct?
Who, the Isaiah?
Yes.
Yes, sir.
He doesn't have a gun in it, does it?
Mm-mm.
That's his right hand. That's the hand that he used to pull it out of his pocket, isn't it? Yes or no, sir?
Yes, sir. Or his left. I mean, I don't tell
Would you
him.
rewind it?
Nah, it was a right hand. It was a right hand.
Thank you.
Don't remind it.
Now, what are you looking at right there?
I was looking forward. I was looking at someone across the street.
Who's in front of you?
Joseph.
Tell me what Joseph is doing.
He's running forward.
Do you recall that now?
Got him.
Is that what you recall seeing?
Yes,
Since it
sir.
refreshes your memory now.
Yeah.
Let me ask you a question.
Yes, sir.
Joseph Harris walked back to you, doesn't he? You're sitting. He stands next to you, doesn't he?
Yes, sir.
He goes up to you and does one of these. Do you recall? A little fist bump at the end?
Here comes the video.
Stated that Isaiah Roscoe was being belligerent and that people were running when he pulled that handgun out. I didn't see anybody running.
There's more people on the other side of the bus stop. There was tourists.
That saw him pull that gun and they ran off?
And yeah, and that homie, that dude's there also. He's there. He's seen it too. All them people seen it. He's seen it. Everybody seen it.
Yes, but you stated everybody started running.
Yeah, the tourist was gone.
Oh, really?
Yeah.
So would it be the tourists that were standing by the bridge?
It was an older Caucasian couple that was sitting a little bit.
Right.
Yeah.
Fact.
Yes, sir.
I mean, these people right here.
Is that them? I'm not sure if that's them or not.
This camera
I
has,
think
the bus had 16
be a
cameras.
fair,
Oh, yeah.
You probably have a fair mistake here. The fact is, they weren't running because Isaiah had displayed a gun towards Joseph Harris and maybe you. They were running because Joseph Harris shot 16 times at Isaiah Roscoe. Correct? So are you going to correct your testimony from earlier stating that they were running because of Isaiah Roscoe was being belligerent and had a gun?
I can't, I wasn't paying attention. Like they could have, after they seen a gun, they could have ran. I'm not sure if they ran because of the shots or because they seen him first. They don't know what he was going to do. So
no, it's fortunate we have a video here.
Yes, sir.
This is brutal, and there's no objections. There could have been a couple objections from the defense already. because the defense was testifying in ways and not. I mean, they're allowed to lead because it's cross, but there were some things that were just not questions at all.
Scratch all that. Oh, that was terrible. I apologize.
This is one of the few witnesses that was going to testify that basically he saw the scenario similar to how Joseph saw it, with the being threatened by this guy who was brandishing a firearm.
Somebody running at this point, right?
Yeah. They were sitting next to me at the time. Then I guess they got removed once they see him do like that. So they were sitting next to me at the time.
So you're saying that these individuals were sitting next to you?
A couple of benches down, yes. They were sitting there. Yes, sir.
They don't look very alarmed. They're just sort of leaning up against the railing there.
Judge, to the form of the question.
Sustained.
There's one.
Do these people look alarmed to you?
Probably not charged as an accomplice.
Yeah, they looking that direction, so they must have seen something. They was sitting next to me. Everybody's seeing it. Yeah, they looking normal.
Mm-hmm. We see a lot of people running now, right?
Objection to the form of the question.
Sustained.
Why was that sustained? He's allowed to lead.
Pass the witness, Your Honor.
Defense.
Nothing further from the witness.
All right, is this witness excused?
Yes, Your Honor.
All right, you may step down. The rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons are you're allowed to speak to our attorneys for the state or the defense.
Yes, ma'am.
All right, thank you.
Okay, I think we get a little bit of a break here. Let's see. Let me see if we can catch. Give me a second here. 1 second. Have to switch devices to play this part. Sorry, I got carried away in the testimony and I wasn't prepared to do this, so give me just 1 second. Looks like jurors are leaving the courtroom right now because we see them going through the door here.
Scratch all that. Oh, that was terrible. I apologize.
Long break, long break, long break. Make sure he doesn't come in here. Just 1 second. Few minutes. Let's go to this one right here. Okay, so now we've skipped the break, or most of it. We're going to be, see a new witness. We're going to be back on defense. We're going to speed this up as well to 1.25 speed.
All right, everyone, please be seated.
And the jurors are back. Yep.
Defense, call your next witness.
Defense called Joseph Harris.
All right, can you raise your right hand for me, please?
Testified his own
Do you
defense.
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
Joseph Harris.
All right, if you'll make sure you keep your voice up so members of the jury and the court reporter can hear. Defense, you may proceed.
Thank you, Judge. Okay. Ms. Harris, do you you live here in San Antonio?
Yes, sir.
And how long you live here in San Antonio?
On and off my whole life.
What I want to do is I want to bring your attention back to February of last year, February 2028 of last year. Does that date, is there anything significant about that date?
Yes, sir.
Okay. What's significant about that date?
This incident that occurred.
Okay.
And also it's my daughter's birthday.
Okay.
Judge, I'm sorry, I'm just having a hard time hearing.
Just
All right. Could you
go
make
up
sure
a
you
little bit
speak
to the
up?
microphone.
Thank you.
It's his daughter's birthday, and it's the date that the shooting occurred.
You said your daughter's birthday?
Yes, sir.
Okay. And how old would your daughter going to be at that date?
She turned 4.
She turned 4? Okay. And you have other children, correct?
Yes, sir.
How many?
6.
So on this date last year, did you have any special plans?
Yes, sir.
Okay. And in those special plans were going to be involving who, your daughter?
Yes, sir.
And and what were you planning to do, if anything, with your daughter?
Your Honor, I object to the relevance.
All right, that'll be overruled.
What were your plans there?
We were going to pick her up early from school and have a surprise birthday party for her.
Okay. Now, it's fair to say that somewhere around 11 o'clock, you find yourself downtown San Antonio, correct?
Yes.
That day. Okay. And where were you at that point? Where, in terms of your plans, where were you going? Where you headed?
I was on my way to the house to go get ready. Get her.
And did you, while you were downtown, did you run into somebody, a friend? Oh, acquaintance.
Yes.
Okay. And that's the same person who testified earlier?
Yes, sir.
Okay. And you recall his first name?
Jason.
Jason. Okay. Did you plan to meet Jason at that?
No, sir.
That was kind of accidental that you ran into him?
Objection, reading, Your Honor.
All right, that'll be overruled.
Yes, sir. Just cross paths.
Okay. And did you anticipate catching a bus?
Yes, sir.
Okay. And what bus were you going to catch?
Whichever, I had multiple buses I can catch, but I was going to catch the one going to the Randolph parking ride.
Okay. So where were you going to go to catch that bus? I mean, when I say on, where you're going to go, where on the streets were you going to go, or stand or sit to wait for that bus?
The bus stop on the corner where we were at, St. Mary's Market.
I'm sorry?
The bus stop on St. Mary's Market.
Okay. So you're seated on the bus bench. And are you engaging in conversation with somebody? What are you doing?
Yeah, we were just talking.
Okay, when you say we were just talking, who are you talking about?
Me and Mr. Jason.
Okay. And once that occurred, did anything unusual happen to you while you were there waiting on that bus?
Just the individual that walked up, came around, acting, speaking weirdly, asking people not to text his phone and this and that.
Okay. You got to try to move the microphone up towards your, so you can. Okay. So somebody kind of walked up.
Yes, sir. Yes, sir.
And did it, when do you recall when you kind of took notice of that person?
I didn't notice him originally, but he had walked around before that at the side bus stop on the other side of St. Mary's Market.
On the market side.
Yes, sir.
Okay. And at that point, were you seated at the bus stops? I mean, on the bus benches on the market side at one point?
Not seated, but was standing talking to Mr. Jason.
Okay. And did anybody approach you and Jason while you were there on the market side of the street?
Just walk by.
Okay. And it was who walked by?
This is the defendant.
It was the deceased.
This is the defendant testifying in his own defense, being questioned by the defense.
Was anything said or communicated to you at that point by the person that walked by?
No, nothing was said. But he seemed to be walking in a fast pace and kind of like his eyes were just kind of like, I can't explain it. Like he was just like staring, but he wasn't. You know, he seemed unusual the way he was walking.
Okay. So did you leave from that location on the market side of the street, on Market Street?
Yes.
Okay. Was there any specific reason why you left?
Well, nobody was there, and I was just like, let's. I was talking to Jason, so I was like, let's move somewhere else so we can, be a little more comfortable because we were already alarmed by that.
Okay. So you walk from the market side. In what direction did you go in?
First, I went to the store, and then told Jason, I'll meet you at the other bus stop. So I came back from the store. That's when I went to the other bus stop.
And when you say the other bus stop, you're talking about on St. Mary's?
Yes, sir.
Okay. So did it come a time that you went to the bus stop on St. Mary's?
Yes, sir.
Okay. Were you able to locate Jason at that point?
Yes, sir. He was sitting at the bench.
Okay. And what did you do?
Just stood there and started talking to him.
Okay. Now, at that point, did anything unusual happen?
We talked for a minute, and then the guy came back around. It's like he went all the way around the block and came back.
Okay. And once this person came back, what, if anything, unusual happened at that?
I believe the first thing he said was, "Stop texting my phone. Stop texting my phone." Hey.
Okay. Did you have your cell phone with you?
Yes, sir.
Okay. Were you texting his phone?
No, sir.
Okay. When he said that, did you take that as being unusual?
Yes, sir, because even the person he was talking to told him he didn't have a phone, he didn't even have his number. So we were trying to figure out what was going on,
So at this point, what happened next?
He said some other things.
Do you recall?
Not every word. Just remember, stop texting my phone, stop texting my phone. And then I remember I couldn't hear everything he was saying because he was kind of turning, but he was also talking.
Okay. So at this point, how close was he to you? Do you remember?
About from here to that small table in front of the
And did there come a time when he did something unusual or alarming?
Yes, sir. Then he pulled his weapon.
Okay. When you say he pulled his weapon, could you kind of stand up and kind of demonstrate what you mean when you say like he pulled his weapon?
He pulled it, but he kept it by his side, and he was kind of just standing there saying, "I guess this is my block, and this and that."
Okay. At this point, you said he was saying what?
This is my block.
Okay. Did you take that to mean anything? Or how did you perceive that?
At that point, I was just confused as to why everything escalated so quickly. I picked my hands up and said, "Hey, can we talk about this?" And he said, "Ain't nothing to talk about. This is my block."
Okay. Was he speaking to you like I'm speaking to you now, or was he loud, or could you describe his voice?
It was aggressive. It was erratical. It didn't make any sense. Anything he was saying, because nobody was texting him. I was just confused. And I'm thinking, with me trying to de-escalate the situation, that I wouldn't think I was in any harm's way. So I was surprised when he pulled the gun.
Now,
his de-escalation was different
you
than
say
mine.
he pulled or displayed this gun. What was going through your mind at that?
I thought he was going to shoot me. I was in fear. I'm trying to get to my children. Everything just happened so fast.
And when you initially saw him with a gun, him in that movement that you made, him pulling it, or what did you physically do anything in response to that?
My first response was to pick my hands up.
Okay, when you say,
like, I picked them up to try to show him I wasn't a threat.
And you held your hands up, or you picked them up, and what happened next?
We both started kind of backing up, and that's when he continued to be aggressive and to say, "This is my block," and this and that. And what is your thought process at this point? My thought process is this guy fixing to start shooting? Is he gonna, at any moment he could shoot? I couldn't see his hands. I didn't know what was gonna happen next because I didn't even expect the gun to come out the first time. So my thought process was just fear. Like, I did not want to get shot.
So at this point, what, if anything, did you do?
At that point, he kept talking, even as he was walking away. He kept talking and turning. I felt at that moment he was fixing to start shooting, because just the way he kept talking and kept turning. So at that point, I made a decision to try to defend my life.
And
ouch.
How did you do that? What did you do?
Pulled my weapon and just started shooting. I didn't,
You say you went towards him.
Yes, sir. And yes, sir. It was so many people around us. I didn't want nobody else to get hit, and I didn't want to hit anybody else behind him. That's why it happened the way it did.
Do you recall whether you did anything to provoke this person?
No, sir. The whole time, all I did was try to de-escalate the situation, which I didn't even know it was a situation.
I'll try not to overthink those two comments together.
Do you actually remember how many times you fired your weapon?
Sir, everything happened so fast. I didn't know how many shots were fired. I didn't know if he was hit or where he was hit. Once I thought that he stopped moving, or he wasn't a threat anymore, that's when I stopped shooting.
And after you stopped firing your weapon, did you leave the scene, or did you stay on the scene?
I stayed on the scene.
And did you yell out to somebody or anybody to do any?
Yes, sir. I asked somebody to call the police.
And you stayed here until the police arrived?
Yes, sir.
In the trial, you heard at least with reference to witnesses, something about a fist pump.
Yes, sir.
Did you Did you remember that?
Yes, sir. Upon recollection, I remember when I returned to the bus stop, individual, which was not Jason, walked up to me and asked me, was I okay? Was I good? And he extended his fist to me. And I said, yes, I'm okay. I'm not pumped. It wasn't a high five. It was like, are you okay?
Okay.
An individual who was not Jason.
State.
Yeah, here we go.
You have talked with each state. You probably know that. Let me ask you. Stated during your interview to the detective, 2 different times you confirmed the detective asked you if Isaiah Orozco was facing you when you first shot. Each time you told him yes. You've seen the video.
Yes, sir.
That's a lie, isn't it?
No, sir.
Objection to the question in terms of lie, improper impeachment, if that's what they're trying to do, Judge.
All right, that'll be overruled. You can answer the question.
No, sir. My recollection of the event when I first gave my statement was fuzzy because it had just happened and I wasn't able to collect my thoughts or anything as far as, you know.
So that's not accurate then, correct?
I wouldn't say it's inaccurate.
Would you like to see the video again? Because he was not facing you when you shot him. Is that accurate or not?
Object to the form of the question. The prosecutor can't testify. You can ask him a question, but he can't.
All right, that'll be overruled. You can answer the question.
As far as I remember, in my memory, he was turning and he was kind of to the side. Yes, sir.
Let me ask you on
This is where it'd be really useful to have the medical examiner's report showing where the bullet strikes struck the body.
your testimony is that he kept turning. Is that right?
Yes, sir. He was walking and then he would stop and he would turn. Yes, sir.
And that's before you shot him.
Yes, sir.
They're showing the video now.
Fair to say at 11:24 and 20 seconds, y'all are facing each other. Is that correct?
Yes, sir.
How big are you, sir? How tall are you?
I believe to be 6 feet, sir.
6 feet. And how much do you weigh, sir?
About 255.
So it's pretty accurate what Detective Ray testified earlier. You're about 6 foot 260. Is that correct?
255, yes, sir.
I'm not trying to. Okay, we'll go with 255. The person, Isaiah Orozco, is substantially smaller than you. Wouldn't you agree?
Yes, sir.
I mean, definitely not even close to 6 feet, and definitely not even close to 255. Is that fair to say?
Yes, sir.
So you're approaching him from the bus stop when you were sat right next to Jason Lexon, right?
No, sir. I wasn't approaching him. I was already at the bus stop.
You didn't get up from your seated position and advance towards Isaiah Orozco.
No, sir. I was not sitting down.
What are you doing right now? Are you saying you weren't sitting down?
Not before the incident. No, sir.
Let's just rewind a little bit, see what's happening here.
Showing you which dark camera 02 at 11:23:57. Tell the jury that wasn't you that was seated on that bench, and you got up and started walking towards Isaiah Orozco.
I didn't see myself seated. I mean,
is this not you right here?
Yes, sir.
Play it backwards, slow-mo.
Around It's at 11:24 and 3 seconds. Now again, you do not see yourself seated on the bench next to Jason Lexon, and then you got up and advanced towards Isaiah Orozco.
I can't see that in the video, sir. It's really fuzzy if you look at it.
Okay, so your testimony is that you can't see it on the video that I just showed you.
No, sir.
Judge wasn't very impressed with that answer.
Here's Isaiah Orozco backing away from you. Is that correct?
Yes, sir.
And it's fair to say here that you were over by, at least you were over there standing. Well, from the video, the jury can decide for themselves, but you were seated next to Jason Lexon. You got up and you advanced on him. You were closer to him than Jason Lexon is. Is that correct from this video alone?
No, sir. That's not what happened.
Okay.
This
is the portion where Isaiah Orozco shows his weapon towards you. Is that right?
Yes, sir.
He doesn't pull up his shirt, does he?
He had to pull up the shirt to get to the weapon, sir.
I mean, is he pulling up his shirt right now?
No, he's actually holding the weapon at this point.
Right, in his right hand, correct?
Yes, sir.
That came from his right front pants pocket, right?
I don't know where it came from. I don't recall where it came from.
Your interview with Detective Ray, you stated numerous times that he pulled up your shirt and kept on showing it to you. And you stated you saw it at least 3 times before you shot him. Is that right?
Yes, sir.
So are you talking about he put it away, brought it back out, put it away, brought it back out, put it away, brought it back out?
No, sir. I say he displayed it, then pulled. Yes, sir.
You said you saw it 3 times.
Yes, sir.
So is this considered one time?
No, that was the last time.
That was the last time. When was the first time?
The first time when you saw me pick my hands up in the video.
On this video?
You paused the video right when I did it.
Okay, I'll rewind for you.
This is
sorry to interrupt you, but please tell me to pause it when you see the gun for the first time and you stated that he showed you the gun.
That's a really smart question.
It was on the other angle, showing it from the front. And you said I got up from the seat.
So this is the last time you're stating to the jury, this is the last time you saw the gun. Is that right?
As far as that, the angle of it, yes.
I'm saying before you shot him or shot at him 16 times, is this the last time you saw his weapon?
As far as from this angle, yes.
So from this angle, are you saying you saw it from a different angle?
Well, I've seen the weapon today. As you said, the last time I seen the gun. I mean, you got to be more specific.
Okay, sir. I'm asking before you shot him 16 times or shot at him 16 times. Okay. The last time you saw it, the weapon, is this the last time you saw his weapon before you shot him 16 times?
Yes, sir.
Thank you.
But I didn't shoot him 16 times.
You're correct. You shot at him 16 times, correct?
Yes.
Thank you.
Wow.
I mean, you're all still having a discussion there, aren't you?
I'm not saying anything.
You're not talking?
No, sir. Only thing I told him was, can we talk about this? That was it. It wasn't any argument or anything. he was still talking by himself.
That's you right there, right? On the screen.
Yes, sir.
It's very difficult to prove perjury. There needs to be like a signed statement. They seldom charge people with perjury.
Looks like you're talking in this video. You motion towards Jason, and you motion back towards Isaiah Roscoe. So what were you saying?
I don't recall what I was saying, but I wasn't talking to Isaiah.
But you're looking at him.
Yeah, we were watching him because he was acting like he was going to shoot us.
Okay. Is that when he was acting like he was going to shoot you? Is that when he put his gun back in his pocket and turned around and walked away and showed his back towards you?
Either way, he was still talking and he was still kept turning. Like
kept turning?
Yes.
Please tell me when he kept on turning around before you shot him.
I didn't say he turned around. I said he kept turning.
What do you mean by turning then?
Like, if I'm talking to you, but
you can stand up if you like.
I'm talking to you, but I'm still doing like this. You know I'm armed. You're going to still be alarmed knowing I have a gun.
Okay. Thank you. So please tell me when he keeps this turning motion that you just showed the jury. If you can tell me as soon as you see it.
So.
Oh, is this the part that you're saying he's turning around again?
No, it was before that.
Oh, it was before that. Okay.
This is when he starts shooting. Oh, man.
Did that part?
Yes, sir.
That's when he's turning?
I mean, you can't see it because of the angle, because this is only one angle. But at this point, he's still talking and he's still, you know.
You can hear him, what he's saying?
Yes, sir. Not clearly, but, you know, you can hear him talking erratically.
Was he saying he's going to shoot you?
He didn't say those exact words, but that's how I felt was based on his actions and his body language and the tone of his voice.
Are you talking about his actions, like putting the gun back in his pocket and turning his back towards you and walking away?
No, that's not what I'm talking about. I'm talking about how he kept on.
Is this the part where you're thinking he's still turning around?
You can see the side of his head right there.
So you're saying that's the turn of his head, not the turn of his body as you displayed to the jury just earlier.
Well, his head.
You can see his right hand, can't you?
Not from my angle. The bus is over here. I'm over here.
Well, yeah, and plus you're busy getting your firearm out of your waistband, right?
No, I think the firearm came out when I was a little bit further up.
You think so?
Just right when I think I took one step and then it came out.
You're grabbing your firearm on this particular frame here.
No, actually, I was taking off my backpack.
Did you take off your backpack?
Just took off my strap off my arm. Yes, sir. I thought I did. Thought I did. I was going to say I don't remember.
Well, it's inaccurate, right? You kept your backpack on.
Yes, sir.
And you watched how many shots you shot there, right? And it's evidence that you shot 16 times because we have the shell casings in evidence, right?
Yes, sir.
And you do see that during your interview, you tell the detective more than once that you stopped firing as soon as he fell on the ground. You recall that?
No, sir. I mean, I recall that, but like I said, I didn't, when the detective interviewed me, my mind was still in the middle of all this, so I couldn't recollect everything.
So you would say you didn't have a clear mind at that time?
Yes, sir. I was no way I could be clear. Like I had just went through all this.
All right, so when you were shooting him, your mind is not very clear.
No, it was clear at that moment. I just knew that I was in fear and I didn't want to be shot.
And when you shot him in the middle of his head, when he's laying on the ground with his hand up, were you in fear of your life?
I didn't know, for one, I didn't know where he was hit at or where he wasn't hit at. But once he stopped moving, that's when I stopped shooting. Because even on the ground, he was still could have been a threat with him moving. He could have still pulled his gun on me and shot me.
So that's why you shot him through the head.
I don't think that was the shot that I did through the head because he had more than one shot in his head. I believe
That's
that.
inaccurate. You heard the ME testify, didn't you?
The ME testified, but he didn't do the autopsy.
He testified that gunshot wound to the head would have dropped him. And for all intents and purposes, his brain is dead. You heard that testimony. You sat over here.
So how many holes was there?
Excuse me?
How many holes was there then?
One, right in the middle of his head.
All right, that'll be overruled. You can answer the question if you can answer the question.
I did not recall shooting him in a particular region. I just know that I was shooting him.
That's exhibit number 68A.
Yes, sir.
You shot 15 times. He falls on the ground. You walk up to him and shoot him through the head.
That's an
objection, Judge. In terms of the question, it's not a question, that's a statement.
Sustained.
That's inaccurate, sir.
Excuse me, when I made an objection, if you don't know whether or not you should answer, just ask me. All right, State, you can ask your next question.
Thank you, Ron. You remember stating to your friend Jamal, you talked to him on the phone when you were in the interview room?
Yes, sir.
You recall stating that it's almost worse when somebody survives?
Yes, sir.
That means it's better if they die.
No, sir. I was referring to myself, the way that they treat you. You defend your life.
And you don't know where the Mr. Orozco lived at, did you?
No, sir.
You also remember stating to the detective that, quote, they stated he's walking away. That makes me look bad on me.
Yes, sir. Because of what the news was saying at the time.
Because in the video, it shows him walking away.
But either way, he was still a threat because he was still accessing his weapon and still talking erratically to me.
So,
thank you,
the video
Tish.
here, you're stating that he had his gun out.
I didn't say he had it out.
I'm asking.
It was in his reach.
Because it is in his reach.
Yes.
You noticed that once he showed you that weapon, what did you do? You backed off, right?
Picked my hands up, started to try to back away. Yes,
So you backed away. And then you saw Mr. Orozco take that gun and put it in his pocket. And he walked away from you. Is that a correct assessment of what we saw in the video?
Pocket, waistband. Yes, sir.
And I believe you use the terminology like escalate and de-escalate.
Yes, sir.
How do you feel? Do you feel that you escalated this situation?
No, sir.
Shooting at him 16 times wasn't escalating it?
No, sir. It was people that told me I probably saved lives that day.
Well, did you put anybody's life in danger by shooting 16 times on a street downtown in the middle of the day? You realize you hit a car that was driving by?
Objection, Judge, in terms of the relevancy of it.
All right, the relevancy objection will be overruled.
No, I didn't realize that, but that was my purpose for running because I was trying not to miss or not to hit anybody else to get hit around us.
So that's why you were chased after him.
Didn't chase him.
What did you do then?
I was shooting So I'm not gonna, when I'm shooting, I'm not gonna just be standing still target, you know.
Was he shooting back at you?
No, but I felt like at any given time I was missing, he could have started shooting back at me. So I didn't know if I was hitting him or not because he was still moving.
So this thing that you're saying that he could have, you're imagining scenarios in your head that could happen.
No, sir.
Well, did it happen?
A gun was pulled on me.
Right, it was pulled on you, not aimed at you. You backed away from it. The individual that pulled that gun put it back in his pocket and walked away from you.
That's not a question. That's a statement.
Sustained.
You notice from the video, has the audio. You shot 15 times. You paused, and then you shot one more time.
Objection. Again,
Is that correct?
Statement. It's a question.
Right, that objection will be overruled.
You can answer the question.
What was the question? One more time.
You saw from the video, it has the audio portion, and the video itself, that you shot 15 times at Isaiah Orozco. You paused, and when he was on the ground, you shot one more time. Is that correct?
No, the pause, I was when I stopped running and my finger hit the trigger one more time. That's when I stopped.
Are you stating that the last shot was an accident?
I'm stating that it wasn't me trying to shoot him while he was already incapacitated. It was from all the emotion and from me running and shooting. It was like the last, like I was running, I stopped. Right when I stopped, the finger hit the trigger again. I didn't walk up on him and shoot him in the head.
You saw the damage to Mr. Orozco's body, correct?
Yes, sir. I've seen the photos. Yes,
You
sir.
heard the ME speak and testify about the last shot, or not the shot that would have caused him to be incapacitated was to the head. You heard Mr. Fowler testify that you shot him in the head. Do you remember that?
I did not. I remember the testimonies. Yes.
Okay. So your testimony here today is that your last shot was an accident.
It was just in the middle, like when all the shots happened so fast, as you could hear. Some people thought it was 5, 6. Some people thought it was 4. Everything happened so fast that when that last shot came out, it was the end of me shooting. But I wasn't trying to unload. I wasn't trying to, I didn't know where I was hitting him at. But once he stopped moving, I stopped shooting. As you heard previously, he was still on the ground moving. So I didn't know where he was hit at.
You didn't know where he was at?
No.
Pass witness, John.
Defense.
Nothing further, Judge.
All right, you may step down. All right, defense, call your next witness.
We approach briefly, Judge.
Yes.
As always, lots of approaching. Okay, well, let's see how long this one takes. Let's skip ahead. Looks like they're about done. I did a little bit of a time warp, not much of one.
All right, so ladies and gentlemen, this is what the court anticipates. Tomorrow, we are going to start exactly at a.m. And at that time, both parties will have a chance to present to you their closing arguments. Before they present their closing arguments, I'll read the charge to you. My instructions are still the same, and I'm going to repeat them because sometimes if you repeat them enough, people will remember. So you all should be able to repeat what I'm about to say to you in your mind since I've said it enough. You are not allowed to watch anything about this case. Make sure your badges are always visible because sometimes attorneys or other people may be talking about this case. You're not to do any research. Everything that you need to know about this case is to come from inside this courtroom and nowhere else. Does everyone understand? When you go home tonight, you're not to start thinking about this case in your mind and deliberating in your own mind. You're not to deliberate with each other. I'll let you know when it's time for you to begin your deliberation. Does everyone understand? All right, we can go off the record. So it is now 8. The courthouse is closed, but I guarantee you, we're not the only people who are still here. So the deputy is going to escort you. And the reason why the deputy is going to escort you is because the courthouse is closed. You can't go the normal way that you usually go to come in. Now, tomorrow we're starting at 10, but
there we go.
The parking garage is still going to be crowded because we still have a number of jurors that come up, and I believe it's like 300 or 400. And everybody who works in this building parks there as well. So if you sort of want to be assured that you have a parking space, 8:30 is probably going to be the time that you need to get here. Otherwise, it's going to be sort of dicey for you to get a parking space. You're more than welcome to bring breakfast or whatever you want to bring to the jury room. All right. Any questions about anything? All right. I'll see you all tomorrow at 10. Everyone, please rise for the jurors.
Okay. So we're starting at a.m. on the dot. The judge right now is actually, I think she's in court right now. Let's see. Maybe she's done.
The video, the clarity of the video?
Jumps to another video. Always goes right back to Judge Darrow. All right. Okay, we have a couple things here. Let me get this straight here. No reserved parking spaces for jurors. No. 11 a.m. Eastern time for trial. That would be half an hour. I'm trying to get the video feed to pop up here live for me from Judge Boyd. Because she has her morning docket. Okay, let's go back. Okay, she's live right now, but she's just got her morning docket going. So we'll pick up with this live when it starts. So I think we start in like 13 minutes or 23 minutes. 23 minutes. Can I bring a llama? Of course, llamas are allowed. So 23 minutes. Too much adrenaline, not in control of emotions, and having a gun is not good. So much of what the defendant said. First of all, I did not know he was going to take the stand. Nobody told me, and so I was completely surprised. I saw him up there. I'm like, wow, that guy looks familiar. Who is it? Oh yeah, that's the defendant. Wow. Brief summary of the case. The defendant, who we just heard testify in his own defense, is accused of murdering the victim, who was somebody who was walking up to them and mumbling or telling people not to call him or text him on the phone, acting a little bit erratically. That part seems clear. A lot of testimony seems to support that. Even the video, I think, shows that he seems to have acted that way. We're hearing, even though it was hearsay, a lot of it was repeated so many times. We're hearing that he was saying something about this was his block, or don't call me, don't text me, and defendant Mr. Harris initially backed down when the victim displayed or brandished a firearm. The victim then put the firearm away and turned and starts walking away while still continuing to apparently talk and make head movements as he's walking away. It was that moment that the defendant chose to defend himself, as he put it, and started approaching the victim and firing until basically his gun was empty. No, I think he might have had 1 or 2 rounds left, but he fired 16 times, with the last shot being after the defendant was on the ground, and it hit him in the head, according to the ME. So, or the replacement ME testimony. It's a bit of a stretch to say that this was self-defense, because generally for self-defense you have to be able to articulate that there is a current threat that the average reasonable person would be in that situation, fear for their life or the lives, the safety of somebody nearby. the fact that he had a gun, I don't believe reaches that threshold. You can't just shoot somebody because they had a gun. Even if they did something sort of brash with it, like brandishing it, you can't just shoot them. That in and of itself does not make that a crime you can defend yourself from. Now, if the argument had proceeded, if he had shown the gun and he had pointed it at any time, or made threatening statements while holding the gun, threatened to end somebody else's life or something like that, then you've crossed that line. You've crossed that line, and then a reasonable person would probably assume that this would result in their death or severe injury, and they could take action to defend themselves. Thanks for not spoiling it for me. Yes, him and his buddy, they sure had a different version of events that didn't quite go along with the video. And now, we have not seen the video yet. I do anticipate once this case is over, that video will be released, or even if it's released in redacted form. I think it would be released, just because how open the Bexar County courts are. So I think we might get to see that eventually, but it just seems like they're seeing something differently than everyone else is seeing on the video. And so the jury, if they're seeing him seated at the bus stop and he says, I wasn't seated, and then he gets up, they're going to know that his version of events doesn't quite match up with what this very trustworthy witness, the camera, observed. All right. Anyway, instead he shot till he stopped moving. Yeah, you can't shoot till they stopped moving. You have to shoot till this threat stops. Once the threat has stopped, you can't continue shooting. His buddy in the end couldn't dispute the video. He tried, but in the end he had to just admit that the camera was right. This probably is a life in prison situation. Victim didn't even have a bullet in the chamber. That in of itself, Babs, that's something we learn after the fact, but nobody could know in the situation. I mean, I from personal experience, I can tell you that there are some firearms, even semi-automatic firearms, like the kinds that the victim had, that have an indicator, a very subtle indicator, that can indicate when there is a round or at least a casing in the chamber. It's so small and difficult to see, and it doesn't exist on all guns, that there's no way for anyone other than somebody who is carefully handling and manipulating the firearm to tell if that firearm is loaded without cycling the action to see if there's one in the chamber. So there's no way to know if any firearm is loaded, and in a self-defense situation, if somebody else has a firearm, you would assume, and it would be safe to assume, and rightfully so, that any firearm that is potentially being used against you is loaded, and you can treat them that way. So, but there wasn't one in the chamber, so it does show that he probably didn't intend to shoot, but his actions, if they were threatening, that intent, that doesn't matter. It doesn't matter if he didn't even have any bullets on him. It wouldn't matter. It's not about what he thinks now. It's about what he believed at the time. Who pulled the gun first? The victim pulled the gun first, Maisel. That's what's so interesting about this case. The victim displayed a gun, didn't point it, didn't threaten. There was no point. I think brandishing is the right term. You're basically being boisterous and saying, and I have a firearm. Okay, so he's saying, this is my block, and see, I've got a gun. That's basically backing up your words with firepower, saying, and I can enforce it. But it doesn't cross that line over to, and I'm going to get you, which there was no testimony that ever occurred. So I don't know. I think it was a very dangerous situation. I think that an officer in that situation, had an officer observed just that interaction, the first part of the interaction before the defendant pulled a gun, I believe an officer would have drawn a gun at this point, but I don't believe they would have fired. I believe if an officer shot in that moment, they would be facing the same charges that the defendant is right now. Pulling is threatening. Sorry, love you, but disagree. But it's perfectly legal for me to hold a firearm and display it to somebody. There has to be another element to threatening. It can't just be possession. It can't just be holding. Judge Boyd said trial will be complete even if it is 1 a.m. Buckle up, could be a long day. She doesn't want her calendar messed up at all. He never pointed the gun. Anybody was the testimony. I think we're probably going to hear in the instructions when the judge instructs the jury something to do specifically with the law regarding brandishing a firearm and threatening and things like that. I can tell you that putting the gun away and walking away with the hands that could reach the gun, or the hand that he displayed the gun with clearly visible, I just don't see that in that moment, at the moment when the defendant took that action, that it was justified. Anyway, so we're going to go ahead and ask a poll for all of you as well, because we believe we've heard all the evidence at this point. And I'm going to start the AC in here because it's like 110 degrees. Sweating like a pig. I know pigs don't sweat, but it's hot. Can't remember the name of my thermostat. How bad is this? I cannot remember how to turn my thermostat on. I know I have an app for it.
Is that correct?
Oh man, my brain is. I think it's Ecobee. There it is, Ecobee. 78. Somebody said it does 78 in my house. They're trying to. I'm being cooked alive like a lobster. This is brutal. Okay, we're gonna down that just a wee bit. Okay. She's scheduled to start a 2-day jury trial tomorrow. She's got back-to-back trials. Jeff says, how broad are the self-defense laws or stand your ground laws in Texas? Here in Massachusetts, self-defense is a tough one. One must do everything possible to retreat. Being able to stand your ground is a huge benefit to anyone who's in any sort of confrontation. So if there's a confrontation, if you have stand your ground laws in the state, generally you don't have to retreat. You don't have to say, I'm trying to de-escalate. I'm trying to get out of the situation. I'm trying to run. I'm trying to end it. Basically, they say you have every right to defend yourself. And in Massachusetts, clearly, as Jeff says, that's not there. Do we have any? Let's see. I'm not sure if Matthew Harris is here. I realize he's not this is not his specialty in criminal defense. But as far as stand your ground in Texas, is that a thing? Defendant's testimony, Christian Mama, was that basically his experience was different than the camera experience. That he saw things differently, that he didn't do things the camera said he did, and he did things the camera said he didn't do. That the victim repeatedly brandished a firearm, and where the camera only caught it potentially one time. He's saying that that he didn't talk to the victim, didn't say anything to the victim, where clearly there's some body language and movement that would indicate that he was talking to the victim. There's a lot of discrepancies between the two stories, and even to the point where the last gunshot, he said, was basically he was shooting, and the last gunshot was him stopping shooting, where the video, from what we can tell, is like bang, 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 15 times, pause, and then bang. So his version of events is very different than what the camera has said. Was it ever clarified the victim legally had obtained a gun? Babs, yes. The guy that the defense brought in first from the gun store, he brought in a form showing that he had legally filled out and properly filled out a form. Whether he lied on it or not, I don't know. But the form is filled out and given and submitted to the FBI for the FBI to do the background check. It's not the store owner's responsibility to research an individual personally and see if there's something that they've lied about on their form. That's what the authorities do. But the store owner does have a responsibility, and the witness to testify to this, that if they observe something that doesn't look right, even if it's just gut feel, that they can stop the sale and say, I can't go through with this. If they believe it's a straw man purchase, they're purchasing the gun for somebody else who legally wouldn't be allowed to purchase a gun. They can end it. But they said there was nothing. He's testified there was nothing in the background check or nothing in what they observed that would indicate it's not a legal purchase for the victim to have purchased a gun. All right. who's... Did any other witnesses hear the get off my block? Because right now it's just him and his friend who heard that. Yeah, and that's this is my block. This is my block. It sounded like a turf battle, you know. And the fact this happened on his daughter's birthday, he should be, you know, going to prepare a birthday party. Instead, he's packing heat down by the local grocery store, getting on the bus. I don't know, what are the laws in Texas? A lot of places, a lot of states where if there's public transportation, you're not allowed to carry a firearm, even concealed firearm, on the public transportation. So you can legally carry a firearm in the state concealed, but on a public bus, you may not be allowed to carry it there. Yeah, 78 is way too warm for all my gear, which also generates a fair amount of heat. Poll results are pretty clear. We're probably the highest we've ever had on a poll right now. It's pretty high.
Sense out of.
Babs, thank you very much. Thank you for the question. I appreciate that. Sometimes I forget that people come and join us every minute of the day and haven't heard what happened for the 20 minutes before. So I'm glad I was able to clarify a little bit for you. Thank you very much. Odds are if you ask a question in here, there's probably 20 other people who are thinking the same question. And thank you for the super chat as well. All right, the cameras in this courtroom are set in a place that does not show the screen. Even though this was a Zoom feed, and the courtroom is using this feed as a YouTube source. So the court is broadcasting to YouTube through Zoom. They go into Zoom, they start the Zoom meeting, and they click the button that says broadcast to YouTube, and it goes out to the judge's YouTube channel. And so the cameras are set up in the courtroom, and the way they're configured is the judge can control them. She has her own camera that shows her beautiful flowers, her purse, and herself. She has a witness camera that'll show the witness. They have one camera that's facing the state and the defense, which should capture the defendant as well. And that's it. And then ideally the jury should not be shown in any of those, but sometimes they get bumped and we get to see the jury like we did today. That's all there is there. I think the judge she's sort of clearing out court right now. I'm just watching where she's
And
at.
is he in custody?
He is, Judge. He's right here.
All right, so Mr. Maldonado is going to be a plea. So deputies, if you'll hold on to him.
Okay, so the judge is clearing out court as we're speaking right now. She's getting set for her 11 o'clock start. I think everyone's... she's getting through some more business. She's working right up to the deadline here. She'll probably take a little break too. Does the judge make money from YouTube? Jenny, I don't know if there's a way I can tell if she does or not. She has 11,500 subscribers and clearly has enough watch hours from what I can observe to show that she would meet the metrics for monetization, but I don't know if legally she could or if that would be a conflict of interest for her in any way. It probably isn't a conflict, honestly. So she may earn some income from YouTube. She's monetized for sure. It's how she pays for her purses. You know something? No, just kidding. She gets those as gifts, I think. Selena says, we have open carry just about everywhere. No weapons in government buildings, schools, and if it's posted, no weapons allowed. Are you down in Texas, Selena? I think everyone's starting to shuffle into the courtroom. Yeah, I'm seeing the defense attorneys there. There's defense taking their seat. We're going to start listening in a little bit right now, in case we get any audio. Hang on, I just reset the wrong video. Here we go. Search Judge Stephanie Boyd. Judge Stephanie Boyd. There we go. We're live. I need to replace this camera over here. Kept hitting the button.
All right.
I wasn't changing the screen.
Have we obtained the birth certificate?
Judge, that's what I wanted to address.
This is a different trial.
Extraordinary efforts to get that, and they haven't. I have a receipt from May 26th where they first tried. There's another receipt from August of this year when they've tried. They contacted the online sources that the court had found for us, and they won't be able to do it because of whatever's happening over the Health and Human Services. They did get their certified letter back, and they're just being told, you gotta wait, you gotta wait, you gotta wait.
All right, did anybody call the state representative for Texas or the U.S. senator?
My mom's just been trying a lot.
All right, somebody called Ted Cruz.
Somebody called
and
Ted
asked
Cruz.
him if we can
Pull
get a
some
birth.
strings.
Yeah, I'm dead serious.
She's serious.
Somebody called one of the state representatives, and when I say state representatives, I don't mean our local or our Texas state representative. Somebody called the representative in the U.S. House, or either call the state senators, the U.S. senator's office, and tell them that you're trying to get your birth certificate. I guarantee you that they will put a quick rush on it. So what we're going to do, we're coming back at 11:30. Somebody step out in the hallway, call the U.S. representative for Bexar County, and call the U.S. senator. And I guarantee you, when you get in touch with the person who works in the office, the first thing they're going to do, counsel, is they're going to see if you're a voter or not. If you're a voter, you know what's going to end up happening? They are going to get that birth certificate.
We'll give it a shot.
I had a similar situation with my mom with regards to her passport, and everyone said it's going to take 8 weeks or 10 weeks. So I ordered it well in advance of that 10-week time period, and it wouldn't come. And I was taking her to Paris for her birthday. And you know what I did? I called her representative from Louisiana, and they were like, oh, we're on it. And guess what? That passport was in the mailbox within 2 days.
Nice.
So I know if you call one of the representatives, we'll get the birth certificate. That's your last.
This is one of the perks that they
So
have.
if you guys will step out in the hallway, call Senator Ted Cruz or whoever else is in the at the Senate level and at the U.S. representative, you'll get your birth certificate.
We'll give it a shot. Thank you.
All right. You're welcome.
She's not kidding. This is something you could do. You can call your senator and say, look, I'm having trouble for this situation. Can you pull some strings to get me my passport processed quickly? Can you get me they can do this.
All right. Can I see the file on Mendez?
We're going to go ahead and close the poll here really quickly. Looks like
I'm
90.
sorry, Ms. Ephraim, what date did you say?
90% of us are saying that he probably is going to be found guilty.
Mm-hmm. All right.
Ivan, it's not her weight that she's
All right.
that
On
she's pulling around.
Joaquin Mendez, Mr. Longacre, Ms. Ferguson, if you could set this in November, his federal trial is October, at the end of October.
It's the constituents' weight. Calling up your representative and saying, hey, you're my representative. I'm having trouble with this. Can you help me? And they can, and they will, because they want your vote. So it's basically a way for them to guarantee
13th.
one vote. She's not saying call Ted Cruz and tell him the judge says to do
Did you
this.
say November the 13th, correct? Yeah.
No. She's not saying that. She's not dropping her name.
All right. And then where is your client?
In custody.
In custody? Where's your client? In custody?
We're
The
gonna
way he
bring them
answered with the
back.
question.
We're going to get ready to bring the jury in a little bit.
Jury's coming soon.
John Carlo Armstrong. Yes. All right, and you're on the other side, counsel.
I apologize.
All right, what is happening with this case?
Judge, this thing is set for Thursday for our first hearing. I'm just reviewing the first amended MTR this morning. I'm also speaking with probation. Mr. Armstrong hired me about a week or two ago. At this point in time last week, he established contact with his probation officer. There was some confusion between pretrial and probation. Probation came over to the residence.
Oh, it's family violence.
No, it's actually gonna be CTD, Judge. So they're gonna be handling it because of my status. So, or lack thereof. And so with regards
My
to
status
this
or lack
case,
thereof.
the probation officer went over to the house, but they said he needed to find a new place. The residence of that house is his mother, who's present today, and his biological siblings who are there. He had been allowed prior to sentencing to be able to live there. Pretrial told him he needed to stay there with his GPS. Probation said he couldn't.
All right, let me ask you this. Have you conferred with the state on this?
We have not, Judge, because it's set Thursday. I just wanted to be able to go back home.
Well, I mean, you'll need to confer with them over this.
We can confer, Judge.
All right, so do you all confer?
Thank you, Judge.
Yes.
Thank you.
Mr. Cox, your client is here. All right.
Judge is just finishing up her docket before the case begins here this morning. Carrie, we are all caught up from last night. We're getting ready for the judge to begin. She says the jury's about to be brought in, so they're close. We can see the defense table. Defense is seated there. I don't know if the defendant is there yet or not. But
all right, court is going to call 2022 CR 3745, State of Texas versus Joseph Dale Harris. Can our parties announce for the record for the state?
Jason Garahan, Daniel Escobar.
For the defense?
Cornelius Cox.
Lorraine Efron.
And are you Mr. Harris? All right, you may be seated. All right, yesterday there was a question by the defense whether or not the complainant had ever been committed to a state hospital. Is that correct, defense?
That's correct, yes.
All right. And neither party objected to the court trying to discover this information because the defense had sought to discover the information but was unable to. After research by the court, which no party had any objection to the court trying to research the matter, the court received information that the defendant had not been committed in the state hospital. Is that correct, defense?
I think you said defendant, Judge, but I think...
I'm sorry, the complainant had not been committed to the state hospital. Is that correct, defense?
Yes. We agree that that information was made available to us in the court.
And that was the information that was made available to the court?
That's correct.
All right. And defense, do you have any information contrary to that?
Not contrary to that. Our position was always that there was evidence suggesting that the complainant had been hospitalized at the state hospital. In terms of the nature and exactly how that came about, we did not have the opportunity to develop that issue.
All right. And the court will note for the record again that according to the court's docketing sheet, that this case has been here with regards to discovery since July 11, 2022. Court will note that the medical records issue were on the court's docket since December 19, 2022.
And if I may respond to that, those medical records that the court is referring to is the hospital records that were conceived when the complainant was when there was an attempt to try to resuscitate him or try to save those. The court is talking about records. In terms of any type of mental health records, that information was never provided to us by the state.
All right. And defense, with regards to that information, it's the court's understanding that on body camera and in the prosecution guide, it stated that allegedly the complainant may or may not have been acting erratically. Is that correct?
That's correct.
And when did the defense have the prosecution guide?
Early in the, at least by the time of this case was actually indicted.
All right. And so that would have been in 2022 at least?
Yes, Your Honor.
All right. And when did the defense subpoena attempt to subpoena the mental health records?
I believe that was the mid-August of this year. That's when we attempted to subpoena those records. And the basis of that was not because of anything that the state provided. Their position was always, we don't know anything about mental health records. And my position is that wasn't true. Well, I won't say it wasn't true, but it was not exactly the circumstance.
All right. The court will note for the record that this case has been on the court's docket since July 11th, 2022. The court will note for the record that the defense was aware of, or should have been aware of, any type of mental health issues since July 11th, 2022. The court will note for the record that the defense did have medical records, mental health medical records subpoenaed in regards to the complainant, and the defense received some of those records. Both the defense and the state asked and had no objection to the court attempting or seeing if the court could discover whether or not the complainant was actually committed to the state hospital, which it was the court's understanding, and which the defense stated that the defense wanted to know whether or not the complainant had ever been committed to the state hospital. And based upon the information that the court has received, which both the defense and the state were made aware of, there has been no civil commitment of the complainant to the state hospital. All right. Is there anything else?
And just briefly, Judge, in our position, the defense position is that those records, that mental health issue, our position is that is consistent with the Brady material. And our position is that for the state to either ignore those issues or not to specifically provide those issues or whatever information they may have in that line is a direct violation of Brady.
All right. State.
Judge, just to respond to that last statement by defense, these records have been and currently still not in possession of the state. And I notified defense counsel Cornelius Cox of that several months ago and mentioned that we did not have these in our possession, nor were they in our possession. So just wanted to put that on the record to make it clear that the state has not been hiding or obtaining records and not turning them over to defense. Everything in the possession of the state has been turned over to defense for this trial and for this case.
And the records you're speaking of are the mental health records of the complainant? That
is correct, Your Honor.
All right. All right. Deputy Laura, can you see if the jurors are here? All right. We will wait for those three jurors.
Three jurors
right, we'll
still trying to find a partner.
Eric Diaz. Is he in custody? All right, come forward.
Quick she is. We'll go off the record. Eric Diaz.
Good morning.
She's very efficient. She's
So
also behind
he's
schedule.
scheduled for jury trial?
Something about this image needs to be adjusted.
All right. All right. So, Mr. Diaz, we'll see you tomorrow for jury trial. Ms. Ferguson will give you a reset form. All right. You're welcome. And counsel, if you're requesting a continuance, you'll need to file a motion.
Jury trial tomorrow for him.
Jesse Inaho. Good morning. How are you doing? Oh, I'm doing great. All right, we're scheduled for jury trial. All right, Mr. Inaho, we'll see you tomorrow for jury trial. Ms. Ferguson, if you'll give them a reset form.
Your Honor, just so the court's aware, I am scheduled for a girls' tomorrow.
Okay. Oh, we'll wait for you. And tell Judge Pulliam I said hello. Thank you.
She's getting rid of some docket stuff while they're working on some things in the background, waiting for the jury.
Too. All right. Can you? All right. Who's here on John Carlos Cisneros Armstrong? Oh, just have a seat. We'll wait for your attorney. And then Carlos Madrigal Hernandez.
That's Mr. Hernandez, Judge.
Okay. And then Mr. DeLeon, your person is Nieves Carrillo?
Yes, Your Honor.
And he's in custody?
She is in custody.
All right. Can you bring her out, Deputy Mejia? Thank you.
Judge is getting some work done during the breaks.
Oh, she's not on the docket? Oh, Deputy Mejia, she's not on the docket. So if you go back there to search, she will not be there. All right, so what are you requesting for this? All right, so what we'll need to have them present. And we'll make that happen. So just get with Ms. Ferguson to see if she can put it on the docket this week.
Judge is getting stuff done.
Yes.
Is it a 3-day weekend this weekend? What holiday's coming up? Did I miss something? I thought we just had didn't we just have Labor Day?
Oh, I like to hunt for which room you're in. All right, and down here. All right, everyone, the jurors are here.
Here we go. Bring the
And
jury.
each side would have 30 minutes for argument. How do you all want your time broken down, State?
Your Honor, I just would like a 5-minute warning before it runs out.
All right.
Judge can give me a 5-minute warning when 5 minutes have expired.
Okay. Defense?
We're gonna do 15 and 15, Judge, and we're asking for a 2-minute warning.
All right.
Defense is going to do 15 and 15 with a 2-minute warning. So they're going to have both attorneys speak in the defense. Some judges only allow one person to speak in closings, but it sounds like we're going to hear from everybody, but a total of an hour in closings. Here we go.
All right, so we're going to go on the record. In 2022 CR 3745, State of Texas versus Joseph Dale Harris. Again, could I have parties announced? Excuse me, counsel, you need to move.
Yeah, the dude.
Could I have parties announced?
Jason Garrigan, Daniel Escobar. Ready?
Defense?
Cornelius Posh and Lorraine Ephron.
And are you Mr. Harris?
Yes, ma'am.
All right, have both parties had a chance to review the charge of the court or the jury charge, State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, any objections to the jury charge, State?
Your Honor, the only, we'd like to put on the record that we were asking for the paragraph 4 on page 5, which speaks about apparent danger to be removed. Off the record, I believe you had already ruled on that it is going to stay, that the state's just objected to that.
All right, thank you. Defense, any objections?
No objections.
All right, let's bring the jury in.
All rise for the jury.
Few people in court. Most of these people are probably here to listen to this case. There are a couple other ones that
Your phones are silent. There is nothing worse when people are doing arguments and the phone goes off. If your phone goes off, just leave the courtroom and wait outside.
Bring the jury.
Yeah, you don't want your phone to be the one that goes off.
All right, everyone, please be seated. All right, defense. Call your next witness.
During this time, the defense rests.
Defense
State.
rests.
State moves to close, Your Honor.
Defense, do you close?
We close.
All right, thank you. All right, ladies and gentlemen, you've heard all the evidence that you're going to hear in this case during this phase. What I'm going to do is I'm going to read to you what's called the charge of the court. You do not have to memorize it. A copy, well, not a copy, the original will be given to you to review. All right. Charge of the court. Members of the jury, the defendant, Joseph Dale Harris, stands charged by indictment with the offense of murder alleged to have been committed on or about the 28th day of February 2022 in Bexar County, Texas. The defendant has pleaded not guilty. 1, our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual.
Closing statements are next.
2, individual means a human being who is alive. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 4, now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 28th day of February 2022 in Bexar County, Texas, the defendant, Joseph Dale Harris, did intentionally or knowingly cause the death of an individual, namely Isaiah Orozco, by shooting Isaiah Orozco with a deadly weapon, namely a firearm, or the defendant, Joseph Dale Orozco, with intent to cause serious bodily injury to an individual, namely Isaiah Orozco, did commit an act clearly dangerous to human life that caused the death of Isaiah Orozco by shooting Isaiah Orozco with a deadly weapon, namely a firearm, then you will next consider whether Joseph Dale Harris acted in self-defense or in defense of a third person or persons, and proceed to paragraph 5. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Joseph Dale Harris, not guilty and do not consider paragraph 5. 5, self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person, one, who has a right to be present at the location where the deadly force is used, and two, who has not provoked the person against whom the deadly force is used, and three, who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force.
So you can stand
If all three of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. A person has a right to defend from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from the standpoint at the time. You are instructed that the defendant's belief that the deadly force was immediately necessary is presumed to be reasonable if the defendant, one, knew or had reason to believe that the person against whom deadly force was used was committing or attempting to commit murder, and two, the defendant did not provoke the person against whom the force was used, and three, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. Excuse me, have a seat. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment. Defense of a third person. A person is justified in using deadly force against another to protect a third person or persons if one, under the circumstances as he reasonably believes them to be, the actor would be justified under the law of self-defense as instructed above and using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person or persons he seeks to protect. And two, the actor reasonably believes that his intervention is immediately necessary to protect the third person or persons. The defendant is not required to prove self-defense, and the defendant is not required to prove defense of a third person or persons. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person or persons. Now, keeping in mind these instructions regarding self-defense or persons, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the charged offense of murder, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person or persons. Self-defense application. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and as instructed in paragraph 4, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, one, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against Joseph Dale Harris, and two, Joseph Dale Harris reasonably believed, presumed to have reasonably believed, as viewed from his standpoint, that his views were immediately necessary to protect himself against Isaiah Orozco's use or attempted use of unlawful deadly force. And three, Joseph Dale Harris's use of deadly force was not in response to verbal provocation alone, then you will find in favor of the defendant on his claim of self-defense and acquit the defendant, Joseph Dale Harris, and say by your verdict, not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and as instructed in paragraph 4, and you further find from the evidence beyond a reasonable doubt that 1, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against Joseph Dale Harris, or 2, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Isaiah Orozco's use or attempted use of unlawful deadly force, or 3, Joseph Dale Harris's use of deadly force was in response to verbal provocation alone, then you will find against the defendant on his plea of self-defense. But next, consider whether the defendant acted in defense of a third person or persons as instructed below. Defense of a third party application. Keeping in mind the instructions above, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and instructed in paragraph 4, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against a third person or persons, and 2, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect the third person or persons against Isaiah Orozco's use or attempted use of unlawfully deadly force, and 3, Joseph Dale Harris reasonably believed or is presumed to have reasonably believed, as viewed from his standpoint, that his intervention was immediately necessary to protect the third person or persons, and 4, Joseph Dale Harris's use of deadly force was not in response to verbal provocation alone, then you will find that the defendant, Joseph Dale Harris, acted in defense of a third person or persons and acquit the defendant and say by your verdict, not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Joseph Dale Harris, committed the offense of murder as charged in the indictment and instructed in paragraph 4, and you further find from the evidence beyond a reasonable doubt that 1, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that Isaiah Orozco was using or attempting to use unlawful deadly force against a third person or persons, or 2, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect a third person or persons against Isaiah Orozco's use or attempted use of unlawful deadly force, or 3, Joseph Dale Harris did not reasonably believe and is not presumed to have reasonably believed, as viewed from his standpoint, that his intervention was immediately necessary to protect the third person or persons, or 4, Joseph Dale Harris' use of deadly force was in response to provocation. 4, Joseph Dale Harris's use of deadly force was in response to verbal provocation alone, then you will find against the defendant, Joseph Dale Harris, on his plea of defense of a third person or persons, and find him guilty of the offense of murder as charged in the indictment. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include, but not limited to Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter to communicate with anyone, any information,
So you just
or
have Rumble
receive
left.
any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by witness to investigators or other officers,
Thank you,
or
Mandy.
police
Thanks for the
reports
super
made
sticker.
by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of the fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, or after considering all the evidence before you in these instructions, you'll acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may begin.
I quickly wanted to cover with you a few things that are in that jury charge. First thing I wanted to say is that you are going to get the jury charge during deliberations. You don't need to memorize anything that I have to say. The first, as Jason mentioned in voir dire, is that there are 2 paragraphs to a murder charge. Now, it doesn't need to be unanimous agreement as to which paragraph applies. If 6 of you say paragraph A and 6 of you say paragraph B, that's enough. Let's go over it. So paragraph A. We've proven the date, February 28th, 2022. Many witnesses came forward and said that was the day that this happened. Bexar County, Texas. This happened a few blocks away from the courthouse. This happened in Bexar County. The defendant, Joseph Harris, multiple people said that the same person that the police ended up apprehending was the same person who shot. And Joseph Harris admitted to the detective that he was the one who fired his weapon. That's not in dispute. Intentionally or knowingly caused the death of Isaiah Orozco by shooting him with a deadly weapon, namely a firearm. None of that is in doubt. Isaiah died as a result of his injuries. The defendant shot at him 16 times. He intended to kill him. Now, many of the elements in paragraph B are similar or the same. Again, the date, Bexar County, the defendant. The main difference is intent to cause serious bodily injury by committing an act clearly dangerous to human life that resulted in the death of Isaiah Orozco. Again, he shot at Isaiah 16 times. He intended to cause serious bodily injury, and it caused Isaiah's death. Either way, the state has proven each of these elements beyond a reasonable doubt. Now, as it's said in the jury charge, you will not be getting any police reports that have been mentioned in this trial. Plenty of them have been brought up. You cannot let bias or sympathy play a role in your determination. You must look at the facts and what's been presented. The state has met its burden. We've shown overwhelming evidence here. We ask that you find the defendant guilty of murder. That the state reserves all remaining time.
All right, defense, are you prepared?
Yes, Your Honor. I was in fear. I was in fear for my life. That's what you heard Mr. Harris say. He was in fear for his life. The state has to prove each and every element beyond a reasonable doubt. They have to prove he did not act in self-defense. They have to prove he did not act in defense of a third person. They have to prove he did not act reasonably. All of those things are presumptions in favor of the defendant. The presumption of innocence alone is enough to say not guilty. But here we have, I was in fear for my life. And we have, stop texting me, stay off my block, stay off my block. Well, he's not saying these words and pulling out his cell phone, stop texting me. No, he's saying these words and flashing his gun, pulling his gun out, right? You are supposed to view this in the eyes of Mr. Harris. Did a reasonable person standing from the viewpoint of Mr. Harris? Now, in this case, you've heard a lot of different viewpoints here, right? We hear from witnesses at this building, that building, here, and the bus, and there's a whole lot of vantage points that you heard from. But the one that matters is Mr. Harris's. And he told you what he observed from where he was standing. He sees a gun. He hears crazy talk. What did you hear the witnesses say today or over this last week? His words were confusing. They did not make sense. They were loud. They were confrontational. They were threatening, erratic, mental, belligerent. You heard witnesses say those things: mental, belligerent, loud, erratic, and he had a gun. And he had a gun. And his cell phone's not in evidence. His gun is. I was in fear. I was in fear for my life. Witness says, you saved lives today. You saved lives today. You saved lives today. That's uncontroverted. That was said to him. Mr. Harris says, I was in fear. I was in fear for my life. And what does he do? He stands there. He says, call the police. Call 911. He did not hide. He did not evade. He did not resist. He stood there. He waited. He asked people to please call the police, call 911, and he waited. And what did he do when the police arrived? He cooperated. He said, I did it. I did it. That's a person who acted in self-defense. That's not a person who has something to hide and is trying to run and hide behind a corner. I mean, this was a busy downtown street and block, right? Lots of buildings around and lots of people around. And that's what you saw from all the pictures and videos. One thing that is over, you see in all of that is all the people that are around, right? And that you confirm are around because that's not, you don't see a 360 view, right? You see trees, you see shadows, you see a whole lot going on, you see city noise, people are hearing and seeing different things from where they stand. But from where Mr. Harris stood, and look, not only several witnesses said he was stop texting me. No one said he had his phone stop texting me. No one understood who was texting him. Who was texting him? Was he getting it from a street lamp to his head? We don't know, right? We don't know if he was getting any actual text messages that day, but we know he was receiving them in some way because he was complaining and he said, stay off my block, stop texting me, here's my gun. The law of self-defense is that a person that a person that reasonably believes that the force is necessary to protect himself. Reasonable belief is a belief that would be held by an ordinary and prudent person in the same circumstance as defendant. It's not any reasonable person. It is a reasonable person standing in Mr. Harris's shoes. I was with my buddy. I was catching the bus. It was my daughter's birthday. I hear this guy. It's so unusual. I hear him. I see him walking around the block. I don't know what's going on with him. And then he starts flashing the weapon. He doesn't have a duty to retreat. He does not have a duty to retreat. He has a gun. He's in fear for his life, and he has the ability to do something about it. He saved his life. He saved others' lives that day. And the presumption of reasonableness goes to Mr. Harris. The presumption of reasonableness goes to him. The state must prove to you he did not act reasonably. And the state cannot prove that because he did act reasonably that day. He has the right to respond to real danger and apparent danger. A gun is a loaded gun. Does anyone dispute that? You see a gun, what else is it but loaded, right? You might be able to clear it and put a zip tie on it later, and hey, it's cleared, it's all safe. But on the street, it's being displayed with some crazy talk. A gun is a loaded gun. That's real danger. It's apparent danger, and it's nothing, no other. The state can't prove otherwise. The state must prove that Mr. Harris, did not act in self-defense. They have not proven that he did not act in self-defense, because he did. He has a right to defend himself from apparent danger, and he did. Mr. Harris gets the presumption of innocence here. Mr. Harris responded in fear. There was not a moment in time where you have, time to analyze whatever. It is happening now, and you have to act. Your life or someone else's. You're going to save your life and the lives of others. You must act, right? And that's what he did. He was in fear. He was in fear for my life. That's what he told you. I was in fear for my life. I was trying to make it to my daughter's birthday party. I didn't want to die that day. I did not want to die that day. And this guy was talking crazy talk and flashing a gun. I didn't know what was up. He was erratic, bizarre. He had a gun. It was a busy street with lots of people around. And I did the only thing I could do. Saved myself and saved the lives of those around me.
Defense.
May it please court.
He's going to waste a whole minute before he starts talking.
Attorneys for the state, members of the jury. This part of the trial is called or known as summation of closing arguments. And basically, this is the time where the warriors have an opportunity to speak to you, to highlight what we feel that the evidence in this case shows. It's important for you to know that what the warriors say is not the evidence. It was a week ago. You all started a journey with us, because in this room, we selected this jury with the responsibility of determining whether the state had proven its case beyond a reasonable doubt. You promised by your oath that you would hold the state to that burden. And if they fail, notwithstanding perhaps your good intention, if they fail to meet that burden, by your verdict, you must acquit the accused. Now, we only have one opportunity to speak, and the state has a second opportunity. So when I'm seated, they can come up and they can say things, and I can't rebut it. So I need to kind of address what they said already and anticipate what they may say when I'm seated and I can't say anything. Proof beyond a reasonable doubt. But first, we thank you for your patience. We thank you for your attentiveness. And we thank you for meeting the challenge of analyzing this case, coming forth with a verdict. Sometimes in trials, like this, what the state is going to do probably is they'll probably show you the video that you see. They may show you the photographs and tell you that there's only one verdict that you must render in this case, because when they show you the photographs, they may show you the weapon and tell you that this case kind of cries out and you need to go back into the jury and the verdict, guilty. Now, I feel that your job is more profound than that. They may come to the state and sometimes they'll pound the desk. They may point at the accused and paint him as a person that's not reasonable, that acted, beyond reasonableness, and you should convict them. But as you think about the evidence in this case, as you go through these sections, or sometimes you may decide with witnesses to take each one's testimony. The question that probably should pop out to you is why. Why? State's correct. February 28th, 2022 was the day of this event. Why? So my client was a typical day. The evidence in this case shows that morning, he had no intent to shoot anybody, to have to defend himself. The only thing that he was considering was catching a via bus and preparing for his 2-year-old daughter's birthday. Question, why? Why does he find himself here today? Typical man. Daughter's birth. Preparation. Now, what you know is that he meets an acquaintance, and they're both going to catch the bus, and they having small talk, and at that nothing at that point in his life, in his experience, that's going to put him in this chair. And what happens? He sees a person who we know at this point is the complaint. He sees this person, and at this point, Mr. Harris is minding his own business, his own business. All of a sudden, he's just yelling by this person. For some reason, there's a fixation with my client and his friend. Why? Why the fixation on those? He's yelling about, why are you on my block? Or this is my block. What? He's seated on a bus bench, minding his own affairs. And all of a sudden, why are you on my block? It's happened to anybody. Why are you on my block? He's waiting to catch the bus. Then, why are you texting? Where does that come from? So in terms of what's, and you heard Mr. Harris testify, in terms of what's going on, you're trying to, in real time, I would imagine, trying to get an understanding of what's going on. Then there's an escalation. Now, the state is probably going to say, well, my client, he escalated the situation. No, where the escalation comes from is that the complainant at this point reveals that he has a firearm, not a cell phone, not a fan to cool yourself. He has a firearm. So you compound what he's saying, the erratic behavior, and now the person exhibits a firearm. Co-counsel was right. So what do? Is not a situation, you see, even in the courtroom, there was firearms that were displayed, and it was always concerned, even in a controlled environment, to make absolutely sure that they weren't active or loaded. You're on the street. minding your own business. Somebody approaches and they got a firearm. Why? I submit to you that when the state comes before you and they want to show you the pictures, let them explain the justification for the complainant to exhibit and be aggressive with the firearm. Why? Why? That's why we're here. And what's the testimony after that? Mr. Harris, he approaches with his hands up. That testimony is not controversial. He has his hands up. Wanting to what? De-escalate the situation. He has his hands up. And the law says, if you look in the charge, that my client, in terms of self-defense, he's in a place lawfully. There's nothing wrong with being in a location that gets us. She's not doing anything illegally. What he does, hands up, and he kind of approaches. And the reason for that is that he wants to de-escalate the
Did they test the guy who was shot for drugs in his system? Y or N?
Stay, and like I said, they may show you the video over again and over again. They may stop. They'll probably try to suggest to you that this person that's speaking erratically, and because that person appears to kind of like turn a little bit, that the danger is over. They may even suggest that because the crime scene technician indicated that there wasn't actually a bullet in the chamber of the complainant's weapon, that he was harmless. If you remember when I asked the witness that how long would it take to rack the weapon? And we started at what, 5 minutes, 3 minutes, 4 minutes. We got down to say maybe a second. And we didn't talk about distance, but even from where he was, even if he backed away, the complainant, he still fired shots. And he had enough bullets in his weapon to kill or hurt a lot of folks at that bus stop. Why? Client only wanted to spend time with his 2-year-old daughter. He wasn't able to. Why? Because he's a citizen, a resident of San Antonio, Bexar County. And he only wanted to sit on a bus bench and wait for a bus to get to his family. Lead detective. And what did the lead detective say? Well, it's my job to make the case, get all the information and decide to make the case or not make it. And there were discussions he talked about. We never heard whether there was any evidence whatsoever that, and the officer testified that they had my client's phone that he or anybody else was texting the complaint. What was the fixation? Why? I asked the lead detective, I said, well, there were, 50, 60 police officers involved in this case. Did you suggest to anybody or yourself to go out and see if you can get other video from other buses in the area that leads up to what happened? The officer says no. The detective said no. Why? Because they were fixated just on the shooting, not about what happened prior to it. The burden that the state has, and we talked about it during jury selection, proof beyond a reasonable doubt, and that burden does not change. I submit to you that this is a case of self-defense, a classic case of self-defense. And you don't have to wait until somebody acting erratic shoots a lot of people before you act. He acted that day. His actions were, from his vantage point, reasonable. And I submit to you that the only just verdict that goes along with the evidence in this case, and no matter how many times they may come and try to point and hit the table, the only just verdict in this case is a verdict of not guilty. Thank you.
Right, State, are you prepared to proceed?
Sure. Defense counsel, court. All right, ladies and gentlemen, I'll be the last person to talk to you today, and then we're going to start deliberating in the back. And not opposed to beating on tables or desks or anything, but I think the facts sort of speak for themselves. You've seen the video numerous times. And yes, I'm going to show the video again in a little bit because we don't get videos like that very often. Defense counsel said this is classic self-defense. Classic self-defense. read that jury charge. I ask each of you, come back in here with a not guilty if you believe this is self-defense. I'll tell you that when Officer Robles arrived at the scene, this is from his body-worn camp. That's how he saw Mr. Isaiah Orozco laying there on his side, headphones near his head, bleeding. Defendant down the road on the sidewalk saying he's the one that shot. Because as Mr. Escobar, my co-counsel, stated, the elements are not in question here at all. The defendant admitted to shooting him. It happened here in Bexar County on February 28, 2022. So I'm not going to even go over that. Because as defense counsel went over the self-defense claim, that's what we're going to focus on. Because that's what they're claiming, that this was classic self-defense. Now, as we go through the witnesses, I'll tell you this. Mr. McDowell, Michael McDowell. Do you believe him? As he stated.
Excuse me, just 1 minute. I'm going to pause you. Deputy, please let her remain outside. All right, you may resume.
Wow. Somebody got kicked
Ladies and
out.
gentlemen, Mr. McDowell, I don't think he has a bone in his body that would be considered a liar. He's very credible. He stated that the individual, Isaiah Orozco, the complainant in the case, was not angry. He was just telling him, stay off my block, stop texting me. You go on to other individuals like William Fowler. You could tell from the way he testified that was a very emotional day for him to witness somebody being hunted down, chased, shot right in front of him numerous times. And the last shot going to the head and seeing what he said looked like confetti coming out of his head, parts of his body flying off his head. That's that last shot. You heard from Gonzalo Salinas that stated that he had a vantage point at 3 stories up. As he looked outside after he heard shots, he saw this man over here walk up to Isaiah Orozco and shoot again. There's that pause in the action. The pause in the action. The kill shot. A shot to the head is what killed this man, no doubt. The fact is, that was the last shot. Numerous testimony from numerous witnesses came in saying that. That man over there chose to do that to that man. Self-defense, classic self-defense. You had Julio Zamora state he heard the shots, he heard that pause, and then the last shot. As he looked out the window, he saw this man walking back to the bus stop by that wall and giving a fist bump. Classic self-defense. You heard from the defendant. You saw his statement. Compare that statement to what he testified to on the stand. It's fuzzy when he was giving his statement, supposedly. He couldn't remember exactly. It was hours after, but he was fuzzy. He couldn't remember. Well, you know, another thing about that is he never saw that video until after. He didn't see that video that day. So he was able to make up his story, because if you go back to that statement, he states there's no videos. There's no way there's a video. It's too quick. By the grace of God, a Via bus pulled up. He didn't know that Via bus had those cameras on there. That's why his statement, when he gave it to the police, was much different than when he got up on the stand and testified to you the other day. He had to correct his story. He had to lie. He had to be fuzzy memory then. You'll look in that video and you'll see Isaiah Orozco doesn't keep on turning around. That's not in the video. You don't see him pulling up his shirt over and over as the defendant gave his statement. You will not see him turn around. You will not see him pull up his shirt. You won't see him display the gun more than that one time. And he puts it down. Now let's talk about self-defense here. Again, justification for Isaiah Orozco to display his gun. I'm going to tell you this. We're never going to know the motive between these two individuals. We're never going to know the history of that, ever. Defense counsel kept on asking why. Well, I told you in voir dire, motive is not an element. So that's off to the side. The why doesn't matter. That's motive. So when we discuss about justifications, defenses to this type of crime, let's talk about Isaiah Orozco. He's having some type of argument, some type of discussion, probably heated, with this individual. Maybe not this individual, maybe Jason Lexon that you've heard testify, which obviously he wasn't very credible. No matter what, there was something going on between them. But Isaiah Orozco stood there discussing with him. He didn't pull out a gun when he was discussing anything with him. But when 6 foot flat, 255-pound man gets up and starts advancing towards him at 5'3" and maybe soaking wet 130 pounds, Isaiah backs up, pulls the gun. What does the defendant do? He stops. He sees the gun. That's reasonable. You see a gun, you're going to stop. He's going to stop advancing towards him. What does Isaiah Orozco do then? After he stops advancing, he puts the gun back in his pocket. He stands there. He gives this signal. You can take for that what you believe that means. And then he points the opposite direction and he decides to turn around. So, self-defense. Isaiah Orozco could use self-defense on himself, for himself, just as this man can. Same. You can. I can. Was Isaiah Orozco reasonable then? He believed he was being advanced upon by a superior individual physically. That he believed possibly that his life was in danger or serious bodily injury.
The facts in the law.
All right, ladies and gentlemen, you remember the witness's testimony as you heard it. And with regards to the law will be given to you in the charge of the court. Yes.
So you determine whether that's reasonable. But no matter what, he puts that gun back in his pocket and decides to turn the other cheek and walk away. And one person decided to pull out their weapon and use it that day. And it's that man sitting over there claiming self-defense, classic self-defense. So when we talk about self-defense, as in voir dire, you saw these charts that I gave you earlier or last week. Remember, I highlighted, reasonably believes that the force is immediately necessary. You tell me that the force is immediately necessary when I have my back towards you and I'm walking away. Walking away. Same thing, deadly force. To use deadly force, what are those highlighted words again? Reasonably believes, immediately necessary. Again, my back is towards you. I don't have a weapon in my hand and I'm walking away. Reasonable belief, it's in the definitions in there, but an ordinary prudent man in the same circumstances that can happen. Reasonably believes that it's immediately necessary to shoot a man 16 times, or rather, shoot at him 16 times. Remember this from the voir dire that I gave you, or in front of you. It's not a future threat. Not that, hey, he's going to come back and shoot you. It must be immediately necessary. Can't be words alone, as a defendant testified to, that when he was walking off, he was saying words. I couldn't hear what he was saying, but it was saying stuff. I implore you that Isaiah Orozco was abandoning this situation. He turned around and left. He was done. This was not a reasonable reaction by the defendant. It was not a de-escalation, it was an escalation. So self-defense especially deadly force, should be a last resort. Use your common sense here. This is common sense, and it's not a classic case of self-defense. Isaiah turns his back and walks away from the defendant. You'll see where they're standing. This is from the video. You see where Isaiah is turning around, and you see the defendant standing off by his buddy, Jason. You'll see Isaiah walking away. He takes 7 to 8 steps. 7 to 8 steps. That's 1, 2, 3, 4, 5, 6, 7, almost 8 before this man opens fire on his back. 7 to 8 steps as he's walking away. Classic self-defense, as defense counsel presented. Defendant chasing down Isaiah. This is where he begins to run. He begins to run after Isaiah. Isaiah's back is still to him. Still. He continues to chase Isaiah until he falls. And maybe he should stop there, but he decides not to. He advances one more time. Those pause in the shots. That 15th shot to the 16th shot, there's a pause. You can hear it on the video. He walks up to him and shoots him in the head. Although, the defendant testified that that was an accident. He didn't mean the last shot. Just happens to hit him square in the head, right in the middle. You saw the pictures of Isaiah's head. Pretty good accidental shot. It's not an accident. He chose to take this man's life. He chose to be the individual that decided whether that man lived or died, because for any other reason other than the defendant, Isaiah displayed a weapon towards him, put it back in his pocket, and turned his back on him. So at this time,
they're going to play the video again.
I'll tell you this, defense of himself, absolutely not classic self-defense. Absolutely not. Defense of the third person, I don't even know why I need to address it, but I will since it's in the charge. Absolutely not. Mr. Isaiah Orozco didn't display that gun to anybody else other than the defendant, because the defendant was advancing upon him and he was a superior physical individual coming towards him. Mr. Isaiah Orozco did the right thing. He put the gun back in his pocket and turned the other cheek and walked off. And that led to his death because he took the high road. Now, maybe having a weapon, you've heard he had this weapon from an artist gun club that he obtained it legally. And as he's walking away, this individual with his firearm takes the low road. Says, not today. I'm going to take you out today. And he does that exact thing. What I can tell you is, don't make this okay. Don't make this okay. Shooting somebody 16 times in the back is not okay. Use your common sense. And I implore you that this is a guilty of murder. Plain and simple. Thank you.
All right, ladies and gentlemen, you've heard all the evidence that you've heard in this case. Each time I keep telling you, I'll let you know when it's time to deliberate. So you're going to be taken to the back where you can select your foreperson and then you can begin your deliberations. If I can have Mr. Gallegos, if you would remain in the box, please. And everyone else, Deputy Moore will take you to the jury room. All right, please slides.
All right, the verdict watch has begun. She said they can start deliberating, so they can start right now.
Right. If I could see defense and state, please.
One more little sidebar. They're probably going to talk about how they're going to get evidence to the jury room, what they're going to send back.
Everyone, please be seated.
We do have a poll going right now about deliberation time.
Not allowed to be in the same room with the jurors while they deliberate. My same instruction will apply to you. Do not start deliberating in front of anybody else. Do not watch anything. Everything that you need to know about this case is to come from inside the courtroom. And I give you these instructions and not release you because something still could possibly happen and they may need you. And in which case, if they do, they'll start deliberating from round zero. And then
she's talking to the extra, the alternate.
I am having lunch orders, so they'll get your lunch. If you go to the back, Deputy Laura knows the drill, and she'll put you in a different location, or you need to walk around. But if you're going to walk around, make sure your bag is still distributed. And then you can take your.
Who's this dude who's walking around the bench here?
All right, thank you. Like, if you guys are just leave your numbers, well, I think everybody has everybody. Oh, is this for
These guys are just ready to take over.
Is this? Yeah. All right.
I'm sorry about that.
Oh. And state defense, if you can make sure that the court reporter has the correct evidence. Oh, you got it? Okay.
I think at this point, the judge is just continuing on her docket while we just go on with things as they are. But murder project is going to continue.
Is there a case on the docket today? All right, you'll need to have the file pull. Have you conferred? No. Oh. Well, I require that people confer. Oh, you need to speak to the state, though. That's what we're here for.
You have to confer. Okay, I've given my opinion. I believe that it was not self-defense. I believe there was not a clear
and deputy, I sent Victor back there. Okay.
I mean, I don't mean that in a.
We're going to turn her down just a little bit here. Verdict watch is underway. Eyebrow time, no. Eyebrows are not sticky anymore.
Yes. Yes. State defense, if y'all could approach. Yes. Mr. Cox? Yes.
She's going to kill the mics. We don't get to hear this. Oh, man. There's the slow speaking defense is right here. How do you feel he gave on his closing? What would you grade him on his closing? She's a super busy judge. Cynicsy 1212, welcome to the gallery. Thank you very much. Good to have you here as a member. Appreciate that. But is it clear murder or should it be manslaughter? It was intentional. Okay, he literally was walking towards and pulled the trigger. I don't think there would be any lesser included. I don't think manslaughter would be appropriate here. Possible hung jury. There's a possibility. I mean, the jury might say it was self-defense. But the way the state spelled it out, especially the scenario in which the victim or the decedent in this case displayed a firearm, it basically said the decedent, he was just talking to people saying, "Don't text me, don't text me, don't text me." Okay, that's not like starting an altercation, even if you're like yelling it out. I don't think that's threatening. He wasn't making any threatening statements to anyone else, and then the defendant walks up on him. Big guy walks up, and then he displays the gun, saying, "Hey, whoa, back up," as he's backing up himself. So it sounds like the victim in this case was using a firearm in self-defense. As soon as the threat went away, he put it away, and he left, and then he ended up getting shot. So the way that was spelled out, I think it was pretty clear. Grade-wise, Z. I guess I should have given a scale. 3, 2.5, a C- for original sin. That's good. I missed the closings. Oh, you've got to go back and watch them. They're only an hour long, but it feels much longer. I'll say, it feels much longer.
Judge, may I approach?
Yes.
I have a jury laptop. So they can watch the TV.
Oh, we do have we have something in the back for that.
Oh, they don't need this?
No.
Oh, okay.
Unless there's a special program that needs to be downloaded, but they'll let us know if they need to view something.
Okay, I'm gonna hold on to it.
Yes.
Okay. Yeah, that would.
All
that'd
right,
be good.
thank
You
you.
hold on to your laptop.
No, this is the jury laptop.
Yes. Yes.
I didn't think they were.
Yes. Yes.
I've got a jury's laptop. F plus 0.1 mile per hour for defense. Is the defendant a prior felon? Julie, I don't believe he was a felon. I believe he's got some prior charges involving a firearm where his gun was taken from him and returned to him by the police. But that obviously would be more prejudicial than probative, and that was not admitted. Why did that gal get kicked out? I think it was a phone call. Phone call during closings after the judge said, turn your phones off. Nothing suspicious. I didn't put any recording devices in this bag or software that pops up that says vote guilty. How many conversations have you had where you're screaming orders to get off your street?
Do you know the rest of the exhibits, or are those the only ones?
Ivan, here's what I'll say.
All right,
here.
everyone, please whisper.
Sorry.
You're still in a courtroom.
I apologize, Your Honor. The only two people who testified he was screaming orders to get off the street, this is my street, this is my street, to me came across as very uncredible witnesses.
All right, who is here on Carlos Madrigal Hernandez?
Morning, Dave. I'm calling on the other time.
So where are we on his birth certificate?
Should I reach out to the federal system? They said no. State system. I called Trey Martinez Fisher's office, left a message. I talked to Cynthia at Senator Menendez's office, and she will be reaching out. I gave her all the contact information for his mother. She said she could.
All right. So did you call the U.S. Senator and the U.S. State Representative?
I called Joaquin Castro, which would be the senator's office. I spoke to a gentleman there. He told me that because it's a state agency and not a federal agency, that I would need to contact the state.
Okay.
And he actually gave me Trey's contact information, but we had to leave a message. I did speak with Cynthia.
Right. All right. So we're coming back next week for an update.
That's fine.
Ms. Ferguson, I need a 1-week reset for discovery on the defendant's birth certificate so that the immigration attorney can determine the status on this case.
And just for clarification, as we've been telling the court before, it's a little bit more complicated than that. It's his mother's birth certificate. She's a U.S. citizen, so that he can.
No, I understand.
He's actually born in Mexico.
All right, we're coming back on September 26th to see what's going on with the birth certificate.
Thank you.
You're welcome.
Okay, we're going to wrap up the poll here in just a
and then
minute.
you're excused.
Approach again.
Just a moment. Who's your client?
Abel Martinez.
All right. Have you asked him to pull the file?
Close top of the PA and they don't have file. Abel Martinez.
Guys, there's a process to follow here in the courtroom. The lady that got kicked
No,
out
is
is
he
back.
on the docket today for his indicted case?
Okay, we're ending the
Okay,
poll
then
right
why
now.
are we here?
Because the defendant came in on the pre-indicting case, and you told me to contact defense counsel.
All right, have a seat. I'll give it to you when it comes up. I have other cases before you.
1 to 2 hours, 53%. 2 to 4 hours, 22%. Less than an hour, 20%. And let's stay the night, only 3%.
All
309
right, I'll
votes.
take it up once he's out here.
So the results are in
Leonardo
chat right now.
Rosales. All right, he needs an interpreter. All right, you need to ask them to call down an interpreter.
I want to see the lady in blue come up and have business before the
Juan
judge.
Charon.
Because she's going to be like, hey, you disrupted.
All right, we're waiting for your attorney.
I'm going to say 1 to 2 hours.
Juan Charon, come up. All right, Mr.
Voir dire.
Teron, you're coming back tomorrow for jury trial.
No relation to Hulk Hogan.
Is there anything else?
There may be some issues to take up before the trial judge, but it's pretty much.
What issue?
Well, like limiting motions and objections to the outcry, submitted questions.
All right.
We're discussing.
If you all will switch sides, please.
Oh, I thought it was.
All right. So everyone,
listen to this.
This is the last time I'm going to say that people need to whisper. If people cannot whisper, what's going to end up happening is while I have people before me, no one will be talking. I'm amazed that people cannot whisper when they're in the gallery and when they're in the audience, but then when they come before me, I can barely hear them because people want to come before me and whisper. That will not happen. So if you cannot whisper in the gallery, and I have to repeat this again, no one will be talking while people are before me. Counsel. So what motions?
Just the usual stuff like limines judge, we've got to make objection to the outcry.
Okay. All right, we'll have the outcry hearing with the trial because I'm assuming the witnesses will be here at that time.
All the kinds of things I'm talking about are housekeeping things that normally you would do before the trial starts. Yes.
Okay.
Although the state and I are also talking about some witnesses and some information we've gathered that we want them to be aware of. How that influences everything, we're not sure. We're sorting all that out.
All right, Ms. Ferguson will give you a reset form. We'll see you back here tomorrow at 9 a.m. All right, thank you. Norma, that's Teron.
I'm nervous to say anything because she might yell at us again.
Juan Carlos Cisneros Armstrong.
Bench warrant. Just kidding.
And we're waiting for the interpreter on Rosales. And then if we could have Abel Martinez come out. Who are the prosecutors on Abel Martinez as a theft of a firearm?
Ooh.
Should be me, Judge.
All right. Have you conferred with the defense attorney on a bond?
Let's do it now in front of the judge.
All right, y'all can have the bond issue heard by Judge Nahara.
Ooh, she's not messing around.
Some other day or today?
Oh, you'll have to file a motion. Is Mr. Teron here?
Yes, Your Honor.
No. I'm sorry. Abel Martinez III. Has he been brought out? All right, Mr. Martinez, if you'll come up.
She's not in a good mood today. I mean, look what she just had to say.
Hello, Mr. Martinez. All right. Mr. Martinez, a charge has been brought against you as theft of a firearm. I'm just going to go over your rights with you because I have to give you your warnings. Okay. I don't know anything about your case, so I can't tell you what the facts of it or what it's about or not. That's your attorney, so your attorney could probably speak to you, okay? All right. You have a right to remain silent. That means that you don't have to speak to anyone if you don't want to speak to them. You have a right to retain an attorney or hire an attorney or have one appointed to you if you can't afford an attorney. Do you have an attorney already? All right. He's right behind you talking to the state and ignoring what's going on at the bench, but that's okay.
Oh,
all right. Goodness. You have a right to have an attorney appointed to you if you can't afford an attorney. You have a right to have a reasonable time to consult or speak with your attorney. You have a right to have an attorney present with you if you decide to give an interview to any officers or any prosecutors. Once you begin an interview, you're allowed to stop or terminate that interview at any time. Do you understand? This is your client. You have a right to have an examining trial. You have a right, if you're not a citizen, you have a right to have your consulate contacted. You have a right, with regards to a court-appointed attorney, they're going to determine if you qualify for a court-appointed attorney or not. So what will end up happening is there's a document that you will fill out, and it's a document about your finances to see if you can afford attorney. If it's determined that you can't afford an attorney, then one will be appointed to you, and you will have suitable time to consult or speak with your attorney. Do you understand?
Yes, ma'am.
And the document that you fill out to determine whether or not you're eligible for a court-appointed attorney, you have to swear to that. Do you understand?
Yes, ma'am.
Right. Once an attorney is appointed to represent you, that attorney will contact you by the next business day. So if you receive your court appointed today and it is 11:39 a.m., they'll need to contact you the next day by 11:39 a.m. Do you understand?
Yes, ma'am.
All right. Do you understand these rights that I've just explained to you?
Yes, ma'am.
All right. Do you wish to have be interviewed for a court appointed attorney? Or do you wish to? Okay. All right. So I'm going to have you sign this document. And the document that you're signing is not an admission to any crime or the admission of guilt to this offense. It's just an acknowledgement by you that I've gone over these rights with you and you understand them. Do you understand?
Yes, ma'am.
All right.
Your Honor, if I may address the court.
Yes.
First, I get two things, Judge. One, public counsel and I have spoken, we've agreed to a $5,000 bond on this case, which would mirror the other bonds that he has on the other two cases. And then as the court appointed, I guess he's going to go through I just want to make sure I'm clear from my own information. I've been appointed on the other two. Will I not automatically be appointed on the third, or do you want him to go through the process before you have to speak to the
court coordinator about whether or not you can be placed on this case as well. It makes sense that you will be placed on this case. And if you'll talk to the court coordinator, I'm sure that Judge Nahara will hear your bond issues today since he's in custody.
Okay. So you had asked us earlier about an agreed bond, and we have an agreed bond. So
all right.
I didn't know if you were willing to take that up now or not.
You'll need to take it to Judge Nahara. Thank you.
She's mad. She's not going to handle that for them because they didn't follow the process.
All right. You're welcome.
Somebody send her a Snickers or something.
Anyone else who's ready, the same rules apply. Just have your file placed up here and the court will take it up. So far, the persons I have are Rosales, but we need an interpreter. The other person is John Carlos Cisneros Armstrong.
I'll get the interpreter before I give you the file.
Okay.
Interpreter online as
All right,
well.
thank you. Sure.
Mr. Rios' side.
She's like, I'm not doing it today. You got to take it to another judge, file a motion.
Your Honor, may I approach?
Yes.
Judge, I represent Martin Rios.
I don't have that file. The two files I have are Leonardo Rosales and John Carlo Armstrong.
Your Honor, if it please the court, I've asked that file be put before the court on
all right. As soon as
today already.
All right. As soon as they put it up here, I will take it up. Could someone put that file up here, please? All right. Where's your client?
Mr. Rios?
He needs to stand on the right side. Looks like he's doing okay.
All right, State.
State's ready on this case, Your Honor.
All right. You're coming back tomorrow for jury trial. Sign the reset form. We'll see you tomorrow at 9 a.m.
Thank you, Your Honor.
You're welcome.
Walter, we watch her every day. She does such a good job, and she's not every day is like this. Realize that when a judge gets ticked off at somebody, and I think she was ticked off at the defense attorney in the jury trial she had already. She's frustrated. She's frustrated what it does to her schedule, what it does to everybody else on that schedule, and so she's not happy. She means business, and she's not putting up hurdles to make it hard for attorneys to handle their client's case. She's like, if you follow these steps, consult with the state, discuss all these issues before you come up here. You have your paperwork ready, stand in a row, just shut up in my courtroom so I can work. Everything will go smoothly. And yes, there was quite a smirk there. Yeah, you missed a little bit, Georgia. It got a little spicy, The judge put everyone in their places. I've never seen it this quiet in our courtroom. It's like a library in there right now.
How about them taggers?
We are trying.
Hey, it started out rough. But
Oh my gosh.
Little sports talk to reset.
So I was thinking about you because I had heard some rumors that you went back home for a short period of time.
Mhm. Yes. Yeah. You know, things always get better. Oh, you're supposed to be behind the line. That's okay.
Stand back.
Yeah. All right. But thank you for that. I appreciate it.
No problem, Judge. Judge,
Is this on the docket today?
no.
Okay.
What I was going to ask for is if you could have that recall for next Thursday. I'm going to be in Oklahoma till Wednesday.
Oh, what are you doing in Oklahoma?
Just going to see my dad again
Oh, okay.
to do his things he needs to do.
Oh, no, I understand. Are you in contact with your client to let them know?
Absolutely. She also has a pending NIMAC case that has not been done.
What did
Okay.
you do, if I may ask?
So,
Yeah, just to move to Thursday, that's all.
so are you saying Thursday, September 28th, or a different
They
date?
did find the F-35. They have located it
All right.
in a rural area in, I believe, still South Carolina. Military has secured the scene. They are collecting it. I did work for the DoD. I ran software that monitored
All right.
hardware.
If you'll give that to Ms. Ferguson so she can put it on the docket.
That's exciting, huh?
Uh-huh.
My computer
Thanks.
watched other computers.
You're welcome. It's always good seeing you guys. I miss you guys. I would see you guys all the time on CPS, but don't see you guys that much here.
Yeah, sure. Insults
Is it? No, not this semester, because I have things I have to take care of in Louisiana.
Oh, okay.
Yeah. But so do you still wait a long time where you have a case set at 1:30 and you're there till 4:30 or 5? Or has it changed?
A little better now they have the other judge.
Yeah.
Just process.
Because now they have 3, right?
Right.
Oh, that's good.
Oh, it helps. But they filed your cases, so.
Yeah.
262 is married to a person.
That is so great.
It's the afternoon where you don't have to be 27. You don't have to be here at 5 o'clock waiting for a 3:30.
Oh my gosh. That is awesome. But you know who I miss? Judge Schubel.
Oh,
yeah, I do too.
He would have his and it would be quick. He'd be like, so what's the problem? Yeah. Status quo, status quo, status quo. Thank you.
Yeah.
All right.
Good talking to you.
All right, you guys too. Have a good one. Oh, well, you know, the courtroom down the hallway, because I didn't want to move because it's expensive for the county to move. But my restroom wasn't working. The heat was horrible. All of the technology started failing. There was a flood. The flood from the DA's office that year, it all flooded down to our courtroom. Furniture was damaged. And I had people to come in and say, oh, the carpet is fine. And I said, the furniture was damaged. They didn't test with readings or anything. And it would always, when we come back from being at home on the weekend, when we come back on Monday, you could smell the mold and the dampness. And so I told them to fix the carpet. They never would. And guess what? We leave. And then I walked there. I'm like, who gave them new carpet?
Of course.
Yeah.
Good seeing.
All right, you too. Have a good one. Immigration? Yes. Sure. What are you approaching on?
She needs to be behind the line. She's muted the mic. All right. Yeah. So this is fun. The judge has a full docket every day, and this is cool. She's in Bexar County, Texas, right here. Bexar County, Texas. That's her, Stephanie Boyd. She has a pretty full docket nonstop. She's just constantly in and out of her courtroom. One of the busiest courtrooms we've ever seen, and she streams almost everything through Zoom like this. So all the people in Zoom are actually in that same room, but she uses Zoom to stream to YouTube. And she has her own YouTube channel where she streams all the court cases. So we're watching along with that. And Bexar County is one of the friendliest counties I've ever I've ever run into, as far as allowing video footage from trial to be used by people like us. So we're super excited, and she's got a personality and a half. She does almost always have flowers. I don't think I've ever seen her without flowers in a vase behind her, and she always has a purse of some sort in front of the vase, and the purse changes every day. I have not seen the same purse twice. Oh man. And they're very, very expensive purses. Pamper Glamper, I can try. My notices when I do a community post don't necessarily go out, but if it happens quickly, we're still going to be live. She needs a cactus.
All right, Leonardo Rosales.
We have a translator.
All right, family violence, this is your case. All right, are you all ready for jury trial?
Yes, ma'am.
And I'm assuming he's already spoken to immigration, is that correct?
Yes, ma'am. I'm providing my counsel.
Okay. All right, this is coming back for jury trial tomorrow.
Thank you.
And if you'll get a reset form from Ms. Ferguson, she will give you your reset form.
Will do, Judge. Thank you.
All right, thank you.
There are going to be like 50 jury trials
Yes,
tomorrow.
once he signs the reset form. All right, and we have one more for you. It's always great seeing you. Who's here on Edgar Aguilar? All right, if you'll come forward.
Method BD group, that is awesome. Yeah, the courthouse is wide open. Basically,
all right, thank you.
You can walk in with the camera and they're cool with it. But yeah, it's if you do attend.
All right, so this case is not
quiet.
actually set for jury trial. What is the status on the immigration? Because the last thing I had was that he had a private immigration attorney.
I haven't actually discussed that with him today, Your Honor. What I have done with him today is extended the plea bargain offer that the state has made. He has rejected it and says that he does want to set it for a jury trial. I believe he is a resident, is that correct?
Yes. All right, we're going to go on the record. Are you ready, Dinah? Court is calling 2023 CR 4709, State of Texas versus Edgar Hernandez Aguilar. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Brittany Mitchell, that's her name.
Megan Enriquez, present for John Coons for Edgar Aguilar.
Are you Edgar Aguilar?
Yes.
All right. We have an interpreter here. If you could raise your right hand. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right. You can lower your hand if you'll state your name for the record.
Norma Nero.
All right. Mr. Aguilar, do you have any objections to this attorney standing in for Mr. Coons?
This is the link I put in the chat right now. This is straight to the judge's channel that we're watching right now.
Counsel, the court has
I definitely recommend giving
on
her a
its
subscribe.
note on the docket sheet that the defendant has a private immigration attorney. Is that correct?
Yes, Your Honor. I did reach out to that attorney after the last setting. I hadn't heard back. However, notwithstanding the immigration issue, the state has made him a plea bargain offer. He is currently rejecting the plea bargain offer and would like a jury trial. So I think that he is a resident, just from what I.
Well, let's do one thing at a time. So the first thing, does he have a private immigration attorney?
Yes.
All right. Do you mind if I put your client under oath to ask the questions as it relates to his immigration attorney?
No problem at all. Your
All right. And I will not go into any attorney-client privilege. Mr. Aguilar, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. Do you have a private immigration attorney?
Yes.
What is that immigration attorney's name?
Ramirez Garcia.
Your Honor, I believe he's stating the name of the firm.
Yes,
All right, so that's the name of the firm?
yes,
So you have hired or retained one of the attorneys at that firm to address any immigration issues you have?
yes,
And that's any immigration issues as it relates to these two charges? Has he made them aware of these two pending charges?
Not to my knowledge, Your Honor.
no,
They,
Oh.
can I ask him?
Yes.
This firm, Ramirez and Garcia, has represented you in obtaining documentation in the past, correct?
yes,
To your knowledge, your ex-wife has not contacted them to make them aware of these criminal charges.
No.
no,
And so they have not advised you on how these criminal charges could affect your immigration status or your residency.
no,
And your ex-wife has not paid them any additional money to advise you on these criminal charges at this time.
no,
Do you plan to use a private attorney to advise you on how a criminal charge could affect your residency? Or would you like the court to appoint an attorney, an immigration attorney, to advise you on how this would affect your immigration status?
Puedo después hablar otras, después puedo ver esto, hablar con mi abogado.
can I talk about this with my attorney?
All right,
Later.
this is what I'm going to do. I'm going to reset this for 30 days. Counsel, are you appointed?
Yes, Your Honor.
All right, I'm going to have an immigration attorney appointed. And Mr. Aguilar, if it turns out that your wife or you wish to hire another immigration attorney, you're more than welcome to do so. But I don't want us to get to the point where we're at a jury trial and then it's, I need an immigration attorney. So, Ms. Ferguson, on this case, I'm going to need a 30-day reset. I'm going to need an immigration attorney appointed. And once that immigration attorney has reviewed everything and given him advice, then I will do a quick turnaround for a plea deadline date.
Understood, Your Honor.
All right.
I can do October 24th.
All right. So we're going to be back on October 24th. And Norma, if you'll let Mac know that he needs an immigration attorney and if you'll stay on top of that, counsel.
Yes, Your Honor.
All right. Is there anything else?
Nothing further at this time from the defense.
All right. Thank you.
Thank you, Your Honor.
Could you imagine if somebody tried to steal the judge's purse?
Yeah, excuse me.
Yes. Thank you so much.
See anything else on the docket or any questions from the jury, Your Honor? Yeah. 10 grand for a bag. That is, that's out of my price range.
And Diana, we'll take a break as soon as things arrive. All right. Are the attorneys here on Fidel Ayala?
Yes, Your Honor.
Ooh, man bun. Man bun for the defense. Fidel is here.
Morning.
Good morning. All right. This is set for jury trial.
Monica Cadetto's ready. I believe the state's ready as well.
That is not a man bun.
All right. We're
That is a man
recalling it for
ponytail.
tomorrow at 9 a.m.
Yes, Judge. Do we need a reset form or?
Yes. Get the reset form from Ms. Ferguson.
All right, thank you, Judge.
You're welcome. Norma Ayala is coming back tomorrow for trial. Are the parties here on John Carlos Cisneros Armstrong, the attorney?
Hours, I don't know if he's coming back today. He might
Okay.
come back.
All right. Who's here on Alexander Leonard Williams?
Morning, Judge. Present.
All right, thank you. Mr. Carbanas, it seems you're always in our court for trial, maybe. Where's your client?
He's in custody, Judge.
All right, come on down, Mr. Williams.
Gail Pett, we are in verdict watch right now as the jury has been deliberating for 35 minutes. This
All
is
right,
roughly
so
the
where are
time
we
the
on this
defense
case?
gave their closing.
Judge, we're ready.
She's done
Okay,
so
and
much.
say which case would you be trying?
We'd be proceeding on the ag assault deadly weapon, Your Honor.
All right, we will see you tomorrow dressed for trial. All right. Is that a Greek symbol on your arm or something else happened?
Oh, that's something else happened. Yeah.
Okay.
Something else happened.
All right, we're going to come back
It's a scar.
on the 20th and you'll be dressed in trial in that outfit, unless there's something else you wish to come to court attired in. If it is, then your counsel will have to make sure that happens. Counsel, if there's an issue with the clothing exchange, just let the court know.
Yes, Your Honor.
All right, is there anything else?
Just 9 a.m. tomorrow, Judge?
Yes.
Thank you, Judge.
You're welcome.
She clearly does not approve of what he was wearing. He's in custody, and he had the right and the option, I believe, to change into other clothing at the clothing exchange. I guess they've got like a closet of clothes where when you're going over to the court, you can find something that fits you roughly and looks good. It was a subtle hint at you probably should wear better than that.
All right, anyone else who's ready, you need to approach the clerk and ask them to pull your file. Otherwise, your case is not getting called.
And confer with the state before you come up there too.
Briella Butler. Briella Butler.
Yes, we are. That's right.
All right, why is she late? She needs to sit on the front row.
We have the victims up there.
Ah, well, if you can put her on the front row over here.
Why is she late? She has to sit on the front row.
Brandon Sierra. Thank you. All right, are you all ready for jury trial?
Good morning, Judge. I am ready for the next 3 days. However, I have a special setting, Judge, in Waco on Monday, the 25th. I just don't think the trial would be finished by Friday.
Oh, it will.
Okay.
We'll stay here. We'll stay here late if we need to be.
Because it's
Gonna get
been
things
set for
done.
more than 90 days out.
Okay.
So I cleared 2 whole weeks because there's about 8 victims on that case.
Oh, Hank, this is family violence. All right, we'll be back on September 20th. Just get a reset form and then you're excused. So how was your trip? I love seeing your photos.
Oh, yes, that was in August, right?
Yeah.
It was really nice. I'd never been to the Aydens out in Spain. So, yeah, it was more than I expected.
See, I'm gonna have to call you because there are some different places I want to visit that I haven't visited yet.
Yes.
I don't swim though, but I figure I can put my toes in the water.
Yes. Well, when we went out in the boat, because I didn't go diving this time, you know, some people didn't go out in the water because, you know, they would stop at some swimming places for, you know, half an hour or something. But still, it's just lovely. The drive out there. Right? Yeah. So, yeah, there's other places that
I'm guessing they're Facebook friends.
to go maybe for next at some point.
Okay, awesome. I'm gonna call you.
Yes, do.
All right, she'll give you the reset form and then you're excused.
Rebus of Kittens, welcome to the gallery. Thank you so much for being a supporter of the channel. We appreciate that. Carissa K says, hey, all, I'm here. See, my favorite channel by far. Thank you, RA. Carissa, thank you very much. Thank you for your 3 months of support as well. It's huge. Thank you so much. Somebody got moved to the front of the class, and we're not sure who it is, but she's late and she's in trouble, and the judge probably have words with her. Ivan says, appreciate mods lately. Can't believe I'm saying that either. We do have the best mods here. We work them both ends of the candle. We burn both ends of the candle on this, and they are fantastic. Let's see. When she says we will stay late, she means it. They were there past 8 last night. Hopefully that won't be the case today. Imagine me Facebook friends with the judge. Think carefully before you post. Very carefully, because you might be appearing before her for something you did. Can you imagine if the judge saw my my live stream when I'm running a red light or something?
Okay, one Ross is here.
It was accidental. Her Facebook,
Briella
Insta, and X
Butler.
are all private. I've checked.
Could I see that file on Briella Butler, please? Oh, is she Briella Butler?
Yes.
Ah, just a moment. Can you call Umberto Saldana and tell him he needs to be here?
Ooh, the lady who's late. The lady who's late is, I believe she's got the red hair that was standing up. She's seated on the front row. Just browsing, can't swim either. You say, dipping your toes in the water is sufficient. My wife can swim, but she doesn't like deep water. And so I don't think I'll ever go on a cruise. But
And where is Nathan Slimane?
I conferred with him this morning, Judge.
All right, let's see if we can get Mr. Slimane back here. And we need Nifa Carrillo and Elizabeth Russell. Oh, okay.
what's funny is as soon as something comes from the jury, she's going to just work it in like it's the next item on the docket. And she's working all day long. It doesn't matter. Jury trial, docket cases. The flowers are multiplying. Yes, we've probably never seen this many. I think we've got 3 vases right now. So I'm wondering if there's maybe a special occasion in her life where she received some extra
And just
flowers.
let me review things with Maldonado, then we'll take it up.
I'm thinking 1 to 2 hours was my call. We're at 41 minutes right now on Verdict Watch. Let's see. I was on the swim team in junior high. It was a community swim team. I think junior high right into high school. Loved swimming. Was never competitive. So I wouldn't say the competitive part. There was no threat that I was ever going to win a race, but I loved swimming, and I benefited from having leg muscles that look like I still swim.
Who's here on Thomas Reyes?
Kevin Curiel, so Judge, on that particular day.
Is he on the docket today?
They're not on the docket. They're on the docket next Thursday.
Mm-hmm.
I'm out of town, and I was just wondering if we could bump him to 10-3 or 10-6 or 10-13, you know.
Usually it's a different purse every day.
Or whatever in the future, but those are just
All right, so what's the date that they're scheduled for?
9/28.
And you can't be here on the 28th?
Correct.
All right. Are you here on the 25th or any of those dates or no?
They look
And
like
are you able to
roses
get in
me.
touch with your client? Are they in custody or no?
No, they're not in custody. So, yeah, 9/25 on Monday, that would be fine.
All right, and are you able to get in touch with them to
I
be
think I
here?
can get in touch with both. So 9/25.
All right, yeah, Norma? On these 2 cases, Reyes, if you'll recall that for 9/25. And I'll give you the files. So it's Reyes and Kevin Curiel. Thank you, Hank.
Yeah, the flowers
You're
don't
welcome.
change every day. She keeps the same flowers as long as they're looking beautiful. Just do criminal. I think, I mean, there's some family stuff in there as well, but I'm not sure how much she gets into. And synchronized swimming, that's impressive. There are enough questions for an interview. She said she might be taking a break soon when something happens. I'm not sure what that is, but we'll watch for that. Butterfly was your thing, says Lizzie. That's a tough one.
All right.
Huge on the
Briella
shoulders.
Butler. We're going to call you back at 1:30. Yes.
I never had the upper body strength I wasn't shaped like a triangle. I could not do the butterfly very well at all. It was all I could do to get my head far enough out of the water to take a breath. But it's an amazing, it's the dolphin kick.
All right, but Sean, that just put a smile on my face.
Okay, so if they take a break, we're probably going to take a break too, but I might need some volunteers to keep an eye on this and let me know if something happens, because this isn't one of those courtrooms where they're going to give us a notice and say in 30 minutes we're going to come in with a question. It's just going to happen, and we'll have to be here or we'll miss it. So we'll have to rewind just for a second if we miss anything. But she ordered lunch. Wrong answers only. Where did she order lunch from? And Ivan's going to say,
were you able to get in touch with Elizabeth Russell?
Oh, baby bear. I'm sorry you're stuck in bed.
Let me see the file on Todd Dotson.
Popeyes.
Is he out here?
Chipotle, Taco Bell.
Mr. Dotson, if you'll come down, please.
Taco Bell's never the answer for anything more than like a midnight run. They urgently need some sort of sustenance, and you don't care about what it does to your body.
Your attorney's not here. They're running late. So we're going to recall you tomorrow. You scheduled tomorrow for jury trial. All right. Is there anything, was the clothing exchange okay? Were there any complications? All right. So we're going to bring you back tomorrow for trial, okay? All right. Thank you for your patience.
Looks like he found a nice white shirt and a little zip-up hoodie in the clothing exchange. He is in custody. So apparently the judge is happy with his selection. Worked out well. We also now offer a zip-up hoodie.
Judge, I got hired on it, Judge.
Okay.
So I'm waiting for an interpreter so that I can.
7-Eleven hot dogs.
Okay. All right. Thank you.
Chuck E. Cheese. Oh, man.
Is your client a citizen or no?
No, Judge, that's what I need to make sure.
All right. Could I see the file on Luis Ramirez Rodriguez, please? So supposedly Mac has already been appointed for immigration issues.
And so we need to, I don't think he's had that interview yet.
Okay. Just give us a moment. And Norma, can you remember to get in touch with Mac and ask them if they have issues where they don't have enough immigration attorneys, just let us know and we can appoint different immigration attorneys.
Okay, so I make fun of this gas station sushi, but I do eat sushi from Sam's Club.
And counsel will take up your matter in just a moment.
And it's pretty good.
Yeah.
Baby bear, that doesn't sound very satisfying at all. I'm sorry we're talking about food here when you can't eat it. Hopefully soon you'll be back to all your favorite foods. Anytime you buy something from a street vendor, you're sort of rolling the dice, and there's like a 50-50 chance that you will have the best food you've ever had in your life. And there's also a 50-50 chance that it will probably kill you. Maybe those odds are a bit exaggerated, but sometimes, I don't know, if you like living on the edge, those street tacos and things like that, oh my goodness. Good stuff. What's this? What is Sam's Club like? A grocery store? It's like a Costco, Stephen. It's connected to Walmart, so it's owned by the same parent company, but it doesn't sell the same items as Walmart. Generally, they sell items that are in larger bulk quantities and different and a full variety. Everything through garden, lawn care, some hardware, office supply, electronics. It's like a Walmart, but everything's bigger. And it's a club store as well. So you have to have a membership to go. SF in Texas gifted a membership and it went to Petrified. Congratulations, Petrified. Good to have you back in green. Those giant soft pretzels, yum. I still have not had the pretzel that I need to eat. I'm supposed to eat a pretzel. Never had one. Never eaten off a food truck. Barb Olson, have you ever bought tamales from a parking lot. You haven't lived unless you bought tamales in a Ziploc bag and from a parking lot. Some of the best food you'll ever have is also very risky. Pretzel and a Monte Carlo. Maybe I can take Mrs. R.A. on a date and knock one of those two off the list today. Hey, Patricia, if you've got a regular where this is what helps the most is if you got a friend who can refer you. It's like, hey, there's a guy who comes around these dates, this parking lot. This is the best place to get your beef tamales, your chicken tamales, whatever it is. You want the referral because there's somebody else who has done the taste test first, and odds are that if they survived, you will probably survive as well.
And Norma, I'm going to need a 30-day reset on Mr. Ramirez Rodriguez.
Sort of the same rules apply.
It's going to be for the immigration issue.
You have to know somebody to find out where they're at.
Okay.
Tamales, oh, good, like corn husk, whatever, wrapped tamales the proper way. So good.
Okay, we can do a barbecue plate sale to afford a massaging chair.
She wants barbecue.
All right, let's proceed.
Barbara's making enchiladas. Dinner at Barbara's house, everybody. Super
All right,
excited.
Mr. Ramirez, if you'll come down.
Okay, Tower Hill Girl. I love tamales. My family does not, but I love
All right,
them.
why is he in a dirty shirt?
Because of the beating.
All right, no, I mean, he doesn't have any clothing at the jail?
That's what they gave me.
Judge, that's what he was arrested with, so I'll make arrangements
Because of
next
the
time
beating?
and do an exchange.
Okay. All right. So my understanding is that you've just been recently hired?
Yes, Judge. The last setting, I was just hired that day. And then we, as you said off record, that we got somebody assigned to him to do a Padilla letter. That I conferred with him, and he has not seen anybody yet.
All right. Ms. Ferguson, can you ask them if they have a backlog with immigration, the MAC? All right. So what we're going to do, if at the next setting you still haven't spoken to an immigration attorney, we can pull another one that's not for MAC. If there are not any objections.
Tower Hill
counsel.
Girl, can you answer this question about the tamales?
So we're going to come back on October 24th. And hopefully at that time, immigration attorney will have a chance to speak with you.
I'm hoping you reveal your recipe.
And the other thing, counsel, make sure that your notice of retained counsel is filed, because on the docket sheet, they still have Ms. Carrillo as the attorney.
Yes, Judge, I'll refile it. I did file it, but apparently.
All right, and we do have forms back there that you can fill out. Yes.
Okay, I'll do that right now.
All right, is there anything else?
No, Your Honor.
And state, I don't believe they're ready to confer about the actual case until the immigration issue is solved.
Yes, ma'am.
All right, thank you. We'll see you back on the 24th.
Legally Gray, welcome to the gallery. Good to have you here.
And that's October 24th.
Let me just say, we're talking about this this Mexican food, which I love.
Thank you very much.
Anybody needs an interpreter?
Let me see. Anyone else need an
The
interpreter?
interpreter's just hanging out here because she keeps being
You're in
needed.
high demand.
I'm going to turn her down just for a minute. Thank you, Legally Gray. Good to have you here as a member. Thank you so much for your support.
5-minute break.
Oh, 5-minute break. Okay, so
And
5 minutes. And she just killed the mic. Okay. All right, so 5-minute break. We're gonna take a little break as well. We're talking about Mexican food. I worked for like 9 years. I worked 9 years for a company that did metal building construction. I worked in the factory that was making components for the metal buildings, and had a lot of Hispanic employees there. I tell you, lunchtime, you would go in and I'd bring like my peanut butter sandwich and whatever, a soda, and they'd bring in like trays, and it was just like they'd set it out around the table, and it was just, you've got the little tortilla and just all the different bowls with food. And it just smelled amazing. And every time they'd be like, "Oh, you want to try one? You got to eat one of these." And I don't know what they gave me, but it would light me up. It would just be like it's like liquid lava in your mouth, but at the same time, the flavor is just to die for. So good, so good. So I love it. Don't forget to peel your tamales. Yes, petrified, like a mango. You'll peel it for sure. Let's see, pork shoulder, ton of garlic, smoked paprika, guajillo spice. I don't know what that is. Pasilla spice, onion, oregano. I don't know. Okay. Flour just to cover the smell of the t-shirts like this. The poor guy, he says, why are you here in dirty clothes? He's like, it's because of the beating. What beating? Man.
Mr.
Ivan, good morning. Good afternoon, I guess. We made it past lunchtime. How are you doing?
My goodness. I feel like it's been weeks since we've chatted. How are you, sir?
It's been a while. Are you doing okay?
Yeah, everything, life in the Northwoods is good. The leaves are changing and the habits continue.
Yep.
And so, how are things in your neck of the heyday?
They're going well. Things are going well. I'm, the channel's doing great. We've picked up a whole bunch of new friends recently, and so it's great to start to get to know some of the new people that are here. And it's
welcome to all new 40,000 of you. Just so you know, I am the moral compass of the show. I am.
We're in trouble.
So, just getting back to our trial with the Judge Boyle trial. Here's my. I know that some people have taken what I've said maybe not the way I want it. This is what I have to say.
Yeah.
I would have never chased him down like that. Ever, ever, ever. Here's what I have to say. The final shot, and I know you probably shouldn't pinpoint it to one specific act of the scenario, but that final shot is actually what does it for me. That's what makes me believe he's got to go away. Now, the time and everything else, we can get into that, but, that final shot where he, because to me, I've stated in the chat, as someone who has been in a scenario where, things are flying and you don't know if you're going to walk out alive, just to me, being shot in the back doesn't do it. That doesn't do it for me alone. But the final run up on him, where he puts that last one in his head, where he's standing over him,
that
right?
Was the crossing the line.
Right. To me, there is no justification. I don't care, like I said, because to me, just running away as somebody who has been in a scenario where your life is on the line, just running away doesn't automatically equal threat is diminished. I know other people have different opinions. Yada yada, but
they could, even though they appear to be leaving, they could turn and be aggressive, and that distance that they've left means nothing.
They could find cover and unload exactly anything, almost like the Travis Rudolph case, right? Where they were running towards their car, but you never knew what they were going to do, right?
Yeah, I don't know. I just. The gun had been tucked away, had been put back in his pocket. The hand that had drawn the gun was clearly visible. I just think as he's walking away with that, I mean, if his hands were hidden and you couldn't tell, the police oftentimes are like, show me your hands. And if there's movement and not showing hands, then there's justification in some cases. But in this one, where the hand was visible, it does, but it takes less than a second to see that there is no gun in his hand right now. And how do you articulate that there is a threat? Just that I think that he might change his mind. I just think that there wasn't a perceivable threat.
Have you ever had a case where they read the charges and they didn't classify the level of murder they were charging?
I think we've had just a straight murder before. It didn't say first degree, second degree. They just said murder, and so I don't know if there's going to be some lesser includeds on the charges. But yeah, the things that look bad, the overkill, 16 shots.
Well, to me, it's not the shots; it's the manner in which the shots were delivered, right? Because shots, the number of shots sometimes gets overemphasized. I'm not going to say it's over dramatic because people have their own opinions, but it's overemphasized in my opinion because shots can fire. Do you know how easy it is to click your fingers 6 times? Guess what? That's 6 shots. It takes less than a second. Like if you're fearing for your life, the number of shots isn't the same as the manner of which the shots were delivered. And that's why that last one to me is so important, because at that point he's standing over him, and there obviously, like, there is no split second threat. Like, to me, that last one is really going to cook his goose, because at that point he was in total control. The threat had been eliminated. The danger had been eradicated, and he chose. To me, that last one was personal. It was to make a point. It was to do whatever, but he did it, and he didn't have to. And to me, that last one is the one that's going to cook his goose.
So if there had only been one shot, and it was the final shot, if that's the only thing he had done, say the guy had tripped walking away from him and he shot once, would that be, throw the book at him, murder?
Wait, say it again.
Take the first 15 shots away. If those had not happened, but you have the same scenario where he's on the ground, like he trips or whatever, as we've heard one witness say he thought he tripped, and then the defendant comes up and puts one shot in.
Yeah.
Is that
you can't straddle a guy? No, you can't straddle a guy with your gun to his head where he has no ability to. No, you can't do that. No, at that point, you keep pointing until somebody calls 911. Yeah. At that point, because you have total control of that situation. That's the whole point of, maintaining or standing your ground or whatever you want, whatever terminology they want to throw at you. The whole point of that is to regain control in which you are no longer fearing for your life. Well, if you're straddling the guy with a 45 to his head and he's got nowhere to move his hands, you've eliminated the threat.
Yeah, I don't know. I think the way the state spelled out how the victim displayed the firearm, it changed it in my mind, because a lot of times all of us, none of us have seen this video. Everyone else has seen the video. We're trying to imagine what they've seen on the video and guess at it, and so that could change everything for us. But when the state describes as him, he's throwing words around, he's being nonsensical, not necessarily threatening, just like sort of weird. This is my block, stop texting me, sort of thing. Okay, he might have been high as a kite. Okay, he might have experienced a lot of things that nobody else was seeing.
There's no indication they knew each other, right? There's no indication they had any prior. Because if there were, they would have brought that out.
Yeah, we haven't heard that. Apparently, the victim or the defendant said that he's done this at other places. Like, this sort of behavior is the same. And he felt like he was stalking him.
Sure.
But when he's doing this, he's doing his thing. He's just having his little high time, whatever it is, with his conversation with himself. And then this guy steps up on him. Defendant steps up on him, and the guy backs up. Okay, and then he brandishes. Then he says, "Hey, I've got a firearm," and sort of pulls it out, say, "Hey, look," puts it back as he's walking away, turns around and leaves. Like, "Hey, don't come up on me. I'm just doing my thing."
Yeah.
That was self-defense. The way the state said that out. That was self-defense. He was like, "Hey, I'm in danger. There's a big, huge dude coming at me. I'm a tiny guy. I display. Hey, I'm not. I'm packing heat." And the guy's like, "Okay, it's good." And he turns around and walks away. So if that was justified for him to be able to display, and I'm not saying it was, but if that was,
I know. Yeah, the specifics of these cases. That's why I hate these cases, because they are always so like in the moment. How do you feel? Like, that's to me, that's why that last shot is so important. Is because even after you erase all the, well, what if, the fog of war, in the moment, chasing him down, eliminating threats, like, all that to me is feasible. But that last one, like, if he doesn't fire that last shot, I think he has a chance of beating this. I really do. Like, especially in a stand your ground state. Like, I don't think, like I said, I don't think turning your back to somebody automatically says the threat is gone. I don't. Because guess what? People run away, take cover, and start shooting again. That happens all the time. Okay, so like, just turning your back on somebody doesn't necessarily mean the threat is eliminated. It just means what it means. But that final one, where like I said, if he doesn't fire that last shot, then he'll probably, like I said all along, I don't think he's faking it. I think he really believes he was justified. I really do. Like, now, whether or not everybody else believes that is a whole other story, but I think he believes. I believe he believes as my mentor always says. And so
I struggle with that because his story didn't match up with the video. And even when everyone else clearly can say what they see in the video and what's happening, he says he doesn't see it. So he comes.
But the way the video, but I don't even like that, because you know what? In a video, like analyzing a video, RA, is hindsight in 2020 at its finest. We can analyze a video. You don't know what you were feeling at that moment. You don't know the vibe at that moment. A video doesn't always tell you everything.
Yeah, it doesn't. It catches from one perspective, and it's very flat. What it sees, it doesn't give you the context and everything else that being in the situation would. But for him saying this didn't occur and it did, or this did occur and it didn't,
right.
That's where I struggle with it. So I feel he lost some credibility in his testimony that way, as his friend did as well.
Okay, y'all appreciate that.
Oh, Judge is back. Hang on one second.
Yep.
Anyway, Judge
All
is
right,
back.
everyone, we're
We'll see you.
going
Love you,
to
Ivan.
take
See ya.
a
Bye.
recess so that the court reporter can have a break. We're going to come back at 1, and we're going to finish everything at 1. So if everybody can be back here at 1, and State, if you will call Mr. Cox and Miss Efron and have them come back, please.
During the break room, they just text me.
All right.
Not in the break room.
All right, so we're going to come back at 1 o'clock, everyone. And then we're going to take.
We're going to take what? What, Judge? You can't leave us. You can't cut us off like that. Okay, so Mr. Cox is the defense attorney for the defendant. She's calling them back to the courtroom. They have half an hour. We might have a verdict after an hour. So 30-minute break. We are going to take that break. We're going to take that break so that everybody can do what they have to do and not feel bad about doing it during the show. So we're going to take a brief break. I'm going to grab a little bit of lunch, see if Mrs. R.I. has some food that she wants to share with me, or I'll just eat off her plate a little bit until she's like smacks my hand, says knock it off. But that'll be good. We'll be back in half an hour. It's going to be quick, guys, quick. So get it all done. Thank you, everybody who's here for the first time.
That under the circumstances to remove Mr. Brooks from.
Sorry. Oh, that's somebody else. Always, Mr. Brooks pops up on YouTube. Okay, so tonight when you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again in about half an hour, maybe with a verdict. Maybe. Fingers crossed. Fingers crossed. CG in Texas says I voted 1 to 2 hours, so fingers crossed. We can do that. See y'all in 30 minutes. Thanks, guys. We'll see you after lunch.
Kick back, taking it easy.